Proceeding will start shortly.
Order. Can I, on behalf of the committee, welcome our panel this morning. David Hennick, Director of the UK Trade Policy Project at the European Centre for International Political Economy. Sam Lowe, Senior Research Fellow at the Centre for European Reform. Dr. Pınar Artıran, Director of the Research Centre for International Trade, Law and Arbitration, Istanbul Bilgi University? Pardon? Bilgi University, and WTO chairholder. And finally, Ruth Lee, Economic Advisor to the Arbuthnot Banking Group. You are all very welcome. As you can imagine, we've got a lot of questions to ask, and not all of you should feel under an obligation to answer all of them, so that we can get through the ground that we would like to cover. I think Craig just wants to place something on the record before we start.
Dr. Ruth Lee is a pass holder under my sort of umbrella within Parliament as one of my research team.
Thank you very much. That is duly noted. Now, just first of all, one can be to be in a customs union, you have to have a common external tariff, but you don't have to be in a common commercial policy. Is that correct? Give us an example of something like that. Mr. Hennick.
So I'll start. The common commercial policy, as defined, is that the EU is negotiating trade agreements on your behalf in goods and in services and in all other respects. A customs union such as that the EU has with San Marino or Turkey means, as you say, common external tariff and no tariffs between on substantive legal trade between members. It does not mean that, for example, the EU negotiates trade agreements on behalf of Turkey.
And what does that do to rules of origin if you're not part of a common commercial policy?
Well, I mean, first of all,
Dr.
if you have a free trade agreement, of course, there would be a problem with the rules of origin. But
yes.
The beauty of the customs union, you are getting rid of the rules of origin. And David is right, is that the European Commission is, negotiating trade agreements on behalf of the European Union. And normally Turkey is supposed to negotiate in a parallel manner with the European Union. But, I mean, we have talked a lot earlier on, and I'm sure you're aware of the fact that there's an asymmetrical relationship between Turkey and the European Union in the sense that once the EU concludes agreements with third countries, then third countries have no longer interest in concluding an agreement with Turkey. This said, we have to comply with the European Union's common commercial policy in the sense there is regulatory harmonization also coming from the Turkish accession to the EU because we're in the process of acceding to the European Union, and also customs union in general requires under 9/95 the customs union decision between Turkey and the European Union, as well as the association agreement of 1963.
Right. But just if a country is in a customs union with a number of other countries but isn't in the common commercial policy, just could you explain to us what happens on rules of origins? If something comes in from a country, say that a deal the UK has done with another country, what happens when those goods then move into the EU with which we might have a customs union but not be part of the common commercial policy?
So a customs union with the EU is lopsided. So
yep.
insofar as whilst the EU could sign an agreement with a country that refused to, in this example, do one with the UK would not be able to do otherwise. There is one example of Turkey having done otherwise, but it wasn't meant to. So that's with Malaysia. But largely speaking, so you do have this issue of circumvention, whereby if the EU were to do an agreement with Indonesia, and the UK were not able to also do a parallel agreement with Indonesia, you could have Indonesian goods entering the UK via the EU at a lower duty than what the UK would charge at its own border. One thing I would say is I think there's some confusion in the UK debate as to what the Turkey does at its own borders when it comes to one of these examples. So, for example, Canada. The EU has an agreement with Canada, Turkey does not. There is this assumption that, therefore, Turkey allows Canadian imports to enter directly into its own market at a lower tariff from Canada. This isn't the case. If you actually look at Turkey's external tariffs and applied tariffs, when it comes to Canada, it still just applies the higher duty. So the risk is for Turkey of circumvention via the EU rather than imports directly from Canada.
Okay, so what would be the advantages to the United Kingdom in being in a customs union with the European Union with a common external tariff, but not being in the common commercial policy, or what would be the disadvantages?
Well, in my humble opinion, I don't believe that scenario actually exists. If you have a customs union with the European Union, you have to be in the common commercial policy. Even if the article...
So it's not on... You think it wouldn't be on offer?
No, because, I mean, first of all, you have to read the provisions of the Article 24, which says actually that you have to apply the same other regulations of commerce, other restrictive regulations of commerce. So there must be a harmonization at the border, equally internally. And for instance, when you look at the documents which, form the customs union between Turkey and the European Union, there are all the time references that once a third country product has been cleared inside the European Union, which means it's in free circulation, then it will have free access to the Turkish market. That's why actually during the TTIP negotiations there was an outrage, in Turkey, because there would be so much trade diversion, because we wouldn't have a trade agreement with the United States. So all of these products via European Union would have free access. That's why then, we wanted to have a parallel agreement with the United States, and all the problems arose afterwards.
Okay.
I would add to that so it's not on offer for the UK to remain party to the EU's common commercial policy as a distinct member. We will be outside of the EU, it is an EU competence. We will be bound to follow the common commercial policy. So if the EU does an agreement with, keep using Indonesia as an example, UK will be bound to seek one as well. In terms of the benefits to the UK of being in a customs union with the EU, at its most basic, so this is before you pile in other things, because it's a framework with which you can pile up other measures, it's that you would, as well as having tariff-free trade, you would not have to worry about rules of origin. And I think the rules of origin issue gets confused, as in people think it's about checks. It's not about checks. It's about whether you qualify for the zero tariff preference afforded under an agreement. If we just had a free trade agreement, lots of exporters in the UK would not qualify for it because they do not have enough local content to meet the thresholds. If you're in a customs union, the assumption is that you do actually meet that threshold for whatever reason, and the default is you qualify for the zero tariff preference. There is, of course, still documentation involved with being in a customs union as well, but that's not the issue. So a customs union in and of itself does not remove any checks at the border, does not remove any documentation, but it does make it much, much easier for UK exporters to the EU, in this example, to qualify for zero tariffs.
Dr. Henning, and then I'm going to ask you, Dr. Lee, about the disadvantages of being in a customs union. Mr. Henning.
This is already sounding quite complicated listening to all of this, and I just wanted to try and because I'm finding it complicated. I think there's some important points that need to be made here. Number one is that a customs union is not some off-the-shelf thing that we just go and pick. Here's our customs union, it's going to be just like the one that Turkey has, or it's going... No, it will have to be negotiated, and therefore many of the things that we're talking about will be subject to fairly detailed negotiations. The second thing is that the customs union specifically applies to tariffs, but it could be extended, as it has been in Turkey, and it must be, to the goods regulation. And an example of that would be that Turkey, for example, follows fully regulations with regard to automotive manufacturing of the EU, and in return it is allowed to have its cars certified to European standards so that they have free circulation. And Turkey, as far as I know, apart from Switzerland, is the only non-EEA country that is part of the EU system for car manufacturing.
Okay,
so that's sorry, just one more thing was on services. So the common commercial policy also covers services. The customs union does not have to cover services. With Turkey, it does not cover services, but maybe we will choose that it should do.
Okay. Now, Ms. Lee, the case against being in a customs union?
I was going to say, I'm no expert on Turkey, let's be honest about this, but I've always regarded the customs union as absolutely intrinsic to the common commercial policy, which is the trade policy, which is actually the EU trading with the rest of the world, to put it in very simple terms. If we were in the EU's customs union, but not in the EU, I would actually regard that as the worst possible world, because the EU could be negotiating trade deals, it could agree trade deals, which is very much in its interest without taking our interest into account. And of course that would mean that the third countries they were actually negotiating the trade deals with, they would have access to our markets through that particular trade deal, but we wouldn't necessarily have reciprocal trade open access to them. So you'd lose that sort of aspect. And I think too that any trade deals that were negotiated by the EU, if we were in the customs union but not a member of the EU, would clearly not take our interest into account. So I do take the view that actually being in the customs union but not in the EU, not having a sort of a seat at the table in the negotiations, would be the worst option for this country.
Now, Mr. Lowe, I think
just to clarify on some of those points, and of course, please disagree with me afterwards. If the EU negotiates a trade agreement with someone else, so I'm just going to keep using Indonesia, the only impact that has on the UK is the tariff level we are able to offer in our own agreement with that country. And we are bound to, in parallel, to negotiate an agreement with that country. So yes, it does come with a constraint in that whatever the EU agrees on tariffs, we also have to agree. However, in other areas where we are not bound by our customs union with the EU, we do have freedom to negotiate as we see fit, be that services, intellectual property, data, procurement. And we have that competence there. So the issue I have with this argument is, does the customs union put constraints on our trade policy? Yes, absolutely. But do we still have to run it ourselves? We do indeed, and this counts for other areas as well. So in the WTO, we would still have to represent ourselves as we see fit. The Commission would not be doing that on our behalf. So constraints, yes, but the UK certainly still has to run its own trade policy.
Okay.
Can I perhaps just comment on that?
Of course.
Because David just was mentioning the regulatory harmonization within the customs union members, and here I would like to refer to Articles 8 to 11 of the Decision 1/95, establishing the customs union between Turkey and the European Union, whereby the European Union says that Turkey has to align its legislation and administrative practices related to technical barriers to trade and conformity assessment rules with the European Union regulation. Similarly, Article 9 spells out the same principle, whereby the customs union would necessitate the internal harmonization of regulations as well, just not the border measures, but also internally. The regulations which are applicable within the customs union members have to be aligned, and in that sense, because the EU already exists as a customs union, the latecomer will have to align itself with the EU's rules and regulations.
Okay. Emma, yes, of course.
Question of clarification.
Emma Reynolds.
Just with regard to what Ruth Lee said about if you're in a customs union but not in the common commercial policy and the EU agrees a free trade agreement, say with Indonesia, I don't really understand this argument or what's been said, and I've heard it before, by the way, that somehow that opens our market up to Indonesia but not Indonesia up to us. Is what causes this lopsided? I don't really...
Talking about when I said about the free trade agreements,
yeah.
If the EU goes ahead and negotiates a free trade agreement, and we would be in the customs union but not in the EU, then that would give the those third countries access to our markets. But unless there were further negotiations, we would not have the preferential access to the third countries' markets that had been negotiated under that particular trade agreement.
That's what I don't understand.
So there's an issue here. So first we need to look at what happens in practice. So as I mentioned earlier, when the EU negotiated an agreement with Canada and Turkey does not yet have one, whilst there is a risk of Canadian imports to the EU entering Turkey via the EU at this lower duty, because it was charged at a lower duty at the EU's border, Turkey does not levy the lower tariff at its own border. And there's then, okay, so why doesn't this happen? There's a question of interpretation over the actual customs union itself, where Turkey shall align its commercial policy, shall align its common external tariff, and the question is how. And the argument could be made that the how is that you negotiate an agreement with Canada, And then there's also a question, and this is a debate, so I'm not giving a definitive answer, but it's when it comes to most favoured nation, is Turkey able to grant a unilateral preference to a country's exports with which it does not have a preferential free trade agreement? Because Turkey does not have a trade agreement with Canada in this example. So how can it grant preferential treatment to those imports? This is a debate because there's an argument as to its obligations to the EU under the customs union, but I come down on the side of Turkey being in the right in not doing what it does.
So you're saying that Canada doesn't have preferential access to Turkey?
Not directly, potentially via the EU.
So it's not the case, but it could be the case.
Well, can I just jump in? Yes, of course it could potentially, but since, the Canada already, signed a deal with the European Union, and because thanks to that deal they will have automatic access to Turkish market if they pass through, European Union market, which then, the product will become, in free circulation, they have no interest in signing a separate deal with Turkey. That's why, in such case, if the Canadian products would like to be directly shipped to Turkey, you may imagine that because of the trade diversion, the country has to take some measures. Now, under the World Trade Organization, there are some trade defense instruments such as safeguards, so you can invoke those measures in order to close your market for a while, but this you can't do, for an indeterminate period of time. So just because I do not have an agreement with Canada, and I will be, deprived from my rights because of the customs union that I have with the European Union, I have to, protect myself somehow. But this also has shortcomings because then I'm in breach of my customs union arrangement with the EU, because normally I have to follow whatever the EU does.
Can I just say that it does not automatically open up our markets, but there's a risk because we have to negotiate other measures to protect ourselves.
I would say on the safeguard measures, that's not actually what Turkey does with regards to, say, Canada or Mexico. It's just it doesn't have an agreement with them, so it doesn't levy that lower duty. Where the safeguards kick in is actually on the circumvented goods. So within the EU-Turkey customs union, there are provisions to guard against circumvention because this was seen as an issue. They were meant to be time limited, and they haven't been. So, for example, Turkey applies a levy on Mexican cars that enter via the EU in order to not only doesn't apply the lower tariff on direct imports, it actually applies an additional levy on circumvented imports as well. However, that was meant to be time limited, and it's been extended beyond what it should have been, because the idea is that ultimately the commercial policies of both Turkey and the EU align, but of course they have had some problems with that.
Yeah, of course.
Okay.
Thank you.
Craig McKinley.
Thank you. I think probably your specialism, Dr. Artıran, will be very welcome by me today. It's been out in the air for quite some time that there is no such thing as no deal. We could have a run-on agreement, perhaps under Article 24 of GATT, to sort of bridge the gap between leaving and negotiating a full Canada-style or whatever style FTA with the EU. So it obviates the need for these wild words like cliff edge and all the rest of it. There is a bridge available under Article 24. There's quite a reasonable paper by the House Commons Library on the issue, and it quotes Dr. Lorand Bartels from Cambridge University, who's done a one-page sheet on what this sort of very basic Article 24 compliant arrangement between an independent UK and the EU could look like until we bridge the gap towards an FTA. Lots of fluff and froth about this, whether it is doable, whether it's not. What are your thoughts? Could this be done as an interim measure while we sort of regather and talk very sensibly with the EU about a future permanent FTA?
Well, first of all, I sort of agree with Dr. Bartels. I think we both, agreed our doctoral thesis on Article 24. So, it's clear to me as well. I agree, to a certain extent with Laurent, whereby if you want to, sign a new deal, first of all, you have to comply with Article 24. And the major, conditions under that is that you have to liberalize substantially all the trade between United Kingdom and European Union, which we never know the definition, but there's an Australian proposal which says 90% of the trade between the constituent members of the FTA or customs union have to be liberalized. On the other hand, to the extent you would like to sign a free trade agreement, of course there won't be a common commercial policy obligation because that is for just customs union. So I have seen the paper which was prepared by Laurent. It seems to me it's fine because to the extent you may actually liberalize trade in industrial products And if the agricultural products is not a major part of the substantially all the trade, I think that would be a viable solution. Now, when it comes to the interim agreements under Article 24, and as stipulated in the understanding on the interpretation of Article 24, again, I think, because you already have an agreement with the EU, you have been involved in a customs union, in a single market, that very definition for interim agreements, which is provided in Article 24, is for new countries which are newly creating a new trade partnership. So I wouldn't, definitely or 100% apply interim agreement provisions to the current statu quo between the United Kingdom and the European Union. But if you want to sign just one paper FTA, I think it's doable. You would just notify to the World Trade Organization. You will show that you liberalize substantially all the trade, and that you did not increase your trade barriers overall towards your third country partners, then I think it should be doable. Because after all, the WTO would like to see the countries to liberalize trade, and I think that's from that angle I think it would be possible.
Okay, Ms. Lee.
I was going to say, I thought that House of Commons library paper, which was called No Deal in the WTO, Article 24, explained, if my memory serves me correctly, I thought it made a very good case that Article 24 could actually be used as some sort of agreement before a final trade agreement was negotiated. But they made the point that it technically would have to be a full agreement rather than an interim agreement. But I think that's partly semantic. But they did make 2 or 3 sort of qualifications on it. The first is obviously we can't do it unilaterally. The EU actually has to agree to it. Well, I think they probably would agree to it given the fact that they have a very large trade surplus with us. And after all, we are talking here about goods and not services, because Article 24, it's my understanding that it is goods and not services. And there's a trade surplus, I think 93 billion it was in 2018, if you think of 95 billion in 2017. By any criteria, that is a very sizable trade surplus for the EU. I think they would agree to it. The other qualification that the House of Commons paper was that it wouldn't cover things like mutual recognition or regulatory alignment, but these are surely not insuperable problems if there is a will for the EU and the UK to actually agree something in Article 24.
David,
if I may come in. I don't regard the WTO rules on Article 24 as a problem to reaching a quick agreement between the UK and the EU, or a quick free trade agreement. The EU, and potentially ourselves, that's the problem with reaching such a quick agreement. And that is because of the power of precedent in trade agreements. So the EU has trade agreements with already 60-odd countries, 35 agreements. And any agreement, they will want to be in line with what they have previously promised to others, because as soon as they give us something different, something more, then other countries will also demand something more. In some cases, that is actually part of their existing trade agreements. In some cases, it is not.
Deal, isn't it?
And to be honest, and I've spent several years in Brussels working on TTIP, the EU trade team and the different countries are all going to have different interests in whether they should do this, what the conditionalities would be of such an arrangement, how services should be included, whether mutual recognition would be included, and the chances of a quick agreement. I mean, if you say a quick agreement to people in the trade world, that's a joke. I mean, I'm afraid we don't do quick. We do long and detailed. And much if we would want to do it, is it in our interest? The EU is not in reality going to sign up to this, I'm afraid, unless we really make a very strong case why it should be done. And I don't think we can, and I don't think they will.
So I find the Article 24 GATT discussion slightly it's a bemusement. It's a sideshow insofar as all free trade agreements are done under these provisions. So that's true. But in terms of the interim agreement, as we've just discussed, it's not something we can decide unilaterally. So actually, what do we have to look at? So is the process by which the EU is prepared to discuss the future relationship, and that brings us back to withdrawal agreement first. So withdrawal agreement, and then within that there is a transition that then applies, then kicks in. So we have our transition where everything stays the same apart from we don't have the say we had before, in which we can use that time to negotiate the future relationship. So that's the process by which the EU has just said it's prepared to discuss the future relationship. So us saying, well, we've looked at GATT 24 and we could do it differently if we wanted, okay, maybe we could, but as it stands, that's not something the EU wants to do.
Can I just conclude with you, Slow, about certain... Oh, yeah.
It says, you just say that's something the EU doesn't want to do. Have they been approached? question. Don't know. I mean, what I find so frustrating about these discussions is that actually we've not even tried. So how do we know? I just don't know. Sorry.
Ms. Lowe, just wanted to pick up on some points that you made regarding circumvention, Turkey tariffs and all the rest of it. So am I right in understanding, say, Turkey's got the same external tariff because it's in the customs union. Mm-hmm. It imports from China, and I'm not going to say a good, maybe, I don't know, garlic or something. There's a 10% tariff to the EU and to Turkey. If Turkey imports it directly, it raises, and does it keep its own EU levy type external tariff? But if it's imported directly to Greece, Greece keeps 20% of it, remits 80% to Brussels, and then, because of the internalisation, Greece could then transfer it across the border into Turkey completely free. So Turkey has received nothing out of its tariff. Brussels has collected 80% of it, and Greece has only collected 20%. Is that the type of arrangement that happens at the moment? Because I'm very worried about what we call the Rotterdam effect.
Right, okay,
if Britain or the UK were in a customs union where we have, it would be landing on EU shores in Rotterdam, tariff collected there, and then over to the UK freely, we'd have collected nothing out of the tariff. Brussels' coffers would have been increased by 80% and obviously Holland's by 20%.
So garlic probably not the best example.
No,
just because agriculture isn't included in the Turkey-EU customs union. But if yes, okay, fine. So you do potentially have this issue that you've raised, whereby Turkey keeps all of its own customs revenue, but if you're an EU member state, you have to divert 80% of that to the EU as part of your budget payment. So if there's a scenario whereby, in our case, the product was to enter via Rotterdam, it would be the EU who collected that tariff and then would then get to keep it, and it would be split between the member state and Commission as per the arrangement in place, and we would not get it. And yes, I think it is a valid point that when it comes to a future UK-EU customs union, because of the Rotterdam effect, there would be this risk of circumvention, and it would potentially be a bit greater than we even see in Turkey's case. However, as David mentioned earlier, knowing this and knowing that a customs union with the EU will be the result of a negotiation, it would potentially, and I'm not saying it would definitely be possible, potentially be possible to bring in some controls to address this, but it would remain to be seen.
I mean, I'd just guess what Brussels' stance would be. We'll say, thanks very much, we'll keep the 80%. I'm just guessing, but I would imagine that would be their own member stance.
It's 80% of the tariff revenue collected by their own member state.
Because I think this is a whole facet of customs union debate that's not getting out there. That this amounts to about £5, £6, £7 billion a year of potentially lost revenue, whereas if you were fully independent raising your own tariffs, you keep the lot. And this has never been mentioned in all of the forums. People are not mentioning these multiple billions of pounds that could be lost to the Rotterdam effect and what the customs union would cost.
I think it's because in the grand scheme of things, relative to the economic impact, the numbers are relatively low. That would be my assumption as to why it hasn't been brought up.
Can I check on that? There'd be no advantage to the importer to land the goods in Rotterdam to then move them to London, as opposed to landing them in London because they're going to pay the same.
Not in this example. No.
So from the importer's point of view, there isn't an incentive to make use of the Rotterdam effect unless they want the money to pass to Brussels as opposed to the Treasury.
Or it's just more convenient to land in Rotterdam. That would be the only.
Right. So it's to do with convenience.
There's no financial incentive to do.
Fine.
To do so.
Can I just clarify this? If in this example something today is landed in Heathrow, it's the case, is it, that 80% of the duty collected goes to Brussels and only 20% stays here? So if we were in a customs union in the future, we would get 100% of that, which is a significant upside for the Treasury, I guess.
Yes.
Yeah, okay. Thank you.
Right.
Although I really wouldn't focus on tariff revenues as being the big issue when it comes to deciding whether to be in a customs union or not. It's really quite minor.
Problem, but there we go.
Sorry, Jim, can I just come? But I mean, the crucial thing in all this is the non-tariff barriers. So, in the case that you were discussing, were these goods to be imported via the European Union and we didn't have a customs arrangement with them, then what would be the practical effect, for example, on the timeliness of goods arriving and disappearing?
it would probably be more costly to import via the EU, because any relationship outside of the EU will have more friction between us and the EU than now, so we're just talking about degrees. And if we are just talking about a basic customs union, potentially with a bit of regulatory harmonisation when it comes to product standards, there will still be additional documentation at the border. Depending on the type of product, there will be risk-based checks, and there will be new delays. So there will be an additional cost that comes with importing in the future in such a scenario via Rotterdam, that, in my opinion, would only make it worthwhile to import via Rotterdam if you were importing into Rotterdam to service the EU as well as the UK. So you were looking across the whole field. If you were just aiming to bring something into the UK, it would make more sense to bring it directly.
So just in terms of the frictionless trade that we aspire to, what is the most frictionless arrangement that we could aim for?
So on goods, so if we keep this just to goods, it would be essentially what you see in the Northern Ireland backstop, insofar as single market for goods plus customs union, plus being within the actual union customs code from the EU's perspective, and having arrangements on VAT to avoid it being a border issue. And then you also need some provisions on services when it comes to transport services. If you can get to that, then as you can see by the backstop why the backstop provision exists, then potentially you don't have any additional friction when it comes to goods on that border. But a customs union in and of itself is not even close to being sufficient.
Okay, Fadl. Oh,
can I just follow up
on this point? All right.
So if the goods, instead of arriving at Rotterdam, arrive at Harwich, then we, if we're inside the customs union but outside the EU, we collect the tariff. Mm-hmm. And then those goods are then, some of those goods are then sent off to the EU. And the EU doesn't get any yield from that tariff. Is that correct?
Yes.
And so so that means that goods could be imported into the UK and then transferred into the EU without the EU getting any benefit from that.
Yes, because now they're in free circulation. Because if you have a customs union, if the products first enter your market, then they are in free circulation. They have been cleared at the UK border, and then they will have free access to the European Union countries, and they won't have anything to charge because you already collected the charges.
But to re-emphasise, they really don't mind, because the point of being in a customs union and the reason it gets rid of rules of origin issues is that you are no longer worried about, so say if you're the EU, a UK company bringing in imports at a lower rate because there's a lower tariff, and therefore their domestic companies getting a competitive advantage over your domestic companies. If the imports and inputs come in at the same rate, that fear disappears, which is why you no longer need rules of origin. So whilst, yes, there is this discussion about tariff revenue, I think if we just played it through, it would probably net off with the UK collecting a bit more than it did before, but in the grand scheme of things, it's largely irrelevant.
Okay. Pat McFadden.
Thank you. Dr. Artıran, I've got a few questions about how the customs union with Turkey works. I should say that doesn't necessarily mean one negotiated with the UK would be exactly the same, but it's an existing example we can look at. Part of the reason for having such a customs union between Turkey and the EU is to facilitate easier trade between the two places. Can you tell us, as well as the customs rules, how much regulatory alignment does Turkey need to follow in terms of single market rules to help facilitate that trade as well?
Thank you very much. I think it really plays an important part of the trade relationship between Turkey and the European Union. At the beginning of the evidence, I had given a couple of provisions from the association agreements between Turkey and the European Union. There is one other one which is very important for the customs union decision, Article 54 of the decision 1/95, and it says the principle of harmonization, which means we need to regulate in a similar manner the product regulations, starting with the technical barriers to trade, sanitary and phytosanitary standards. So that started already in 1963. And one thing that actually I wanted to add, for instance, that agreement, the first start of the Turkey-EU partnership was notified as an interim agreement. And I found some documents which were discussed in the GATT Working Party report, whereby both the European Union, at the time it was called European Communities, and Turkey actually told that their agreement in 1963 was an interim agreement. At the time, some some GATT members had opposed to this agreement, saying that, well, you don't have a clear plan, we don't know how long this is last. But both the European communities and Turkey took the stance that this was an interim agreement, which would then be coupled with an additional protocol in 1970, and then which culminated in 1995 with the customs union decision. So the entire engine that we have, starting with that agreement in 1963, with the additional protocol in 70, and with the customs union, they all foresee a regulatory harmonization inside. And I think that facilitates trade between Turkey and the European Union. For instance, just think about the CE trademark, the CE logo. Once we see that, at the border, it will have, very easy access to the market. Whereas if we don't see that CE brand, if UK ever leaves the European Union and you no longer have the CE mark, then you will have some problems when you ship your products to Turkey. So all of this harmonization, actually the non-tariff barriers, is a good thing under the customs union. It's not only about tariffs, but actually non-tariff barriers are very effective and you can get rid of them, which I think is the most helpful part of that.
I would just add a couple of points to that, which is that, firstly, Turkey is, of course, an accession country to the EU as well, and there is some debate as to how much of the customs unit, the design of that originally, takes account of the fact that Turkey is an accession country, and particularly in view of the second point. So the EU, we hear so often, the EU says the single market is not divisible. Well, in the case of Turkey, it clearly was. Now, probably the EU would argue that was because Turkey was on an accession track, and therefore it was envisaged that it would go towards full harmonisation. The point that I'm trying to make in all of this is it is not clear that the same thing will be on offer to the UK, though taking into account my precedent point earlier, it would be hard for the EU to say we're not going to do it, but there is a reason the EU could turn around and say that's different, Turkey was an accession country, you can't have this or what, or this in terms of the regulatory side.
Okay. The point I'm trying to make clear is that we shouldn't just think about this in terms of duties and tariffs, but is in addition, if you're interested in frictionless trade or trade as frictionless as possible, whatever phrase you want to use, there are regulatory rules as well as those normal customs rules. So let me just try and probe this a bit more. If you think of a product, let's say a car, Turkey makes cars, that car made in Turkey has to abide by the same product standards as a car made in Germany or France or the UK. But when we think about the single market rules, there are the product standards in terms of, say, the emissions from the car or the safety standards and so on, the actual core to the product. And then there's a whole load of other single market rules around the working conditions in the factory, environmental standards and so on. Again, to Dr. Artıran, can you give us some kind of picture of when we talk about regulatory alignment, how much of that body of single market rules does Turkey have to follow, including, if you like, those social and environmental things, as well as the core product standards rules?
Thank you very much. That's an excellent question. I mean, we didn't have, for instance, let me start with the social and environmental standards. That wasn't covered in the Turkey-EU Customs Union and Association Agreement. Separate. But that, came later on. And when you look at the recent talks, well, I mean, unfortunately, the talks have been suspended for the modernization of Turkey-EU Customs Union, but it's on the table. So when we had prepared this report, this impact assessment report for the European Commission 3 years ago, in that report the European Commission was foreseeing that in the revamped negotiations, European Union would impose the environmental and social standards as well. As it stands, we don't have them, we don't apply it, but the single market today in the existing customs union, we have to align with the technical barriers to trade regulations, with sanitary and phytosanitary standard, everything which is about product safety. But the other things regarding environmental standards and product, the human rights standards, etc.
Labour market?
No, they're not allowed for the time being.
I would say if we're looking at this to inform our view on the future UK relationship, we do already have a customs union text that exists between the EU and the UK in the form of the all UK customs arrangements in the backstop. So we can see from that when it comes to an EU customs union with the UK, they would require these level playing field provisions. So it would go into environment, labour, social, but also things like I've just blanked on the word, when you pay businesses money to...
State aid.
State aid, sorry, yes, sorry. I just thought that would be front of mind. But yes, so we can see that within that customs union that is envisioned, in the event that we go into the all-UK customs union as part of the backstop, then those provisions would be included. And that tells me that if we were to actually negotiate a long-term customs union with the EU, those would be required. On the impact of alignment in the case of Turkey, we should say that whilst it has been asked to harmonise in these certain areas, whilst it can make authorisations that potentially other non-EU members, apart from Switzerland, struggle to do, this doesn't actually lead to less friction at the border.
Well, that's my next question.
Yes.
If I may move on to the border.
May I perhaps just comment on that? Because we already have, for instance, competition rules, state aid rules are covered in Turkey-EU customs union. Yes, we don't have labour standards, we don't have environmental standards, but competition rules was imposed already from the very beginning, and I think it worked very well in Turkey, because the competition authority was established in 1995, and it works very well, and the reports by the European Commission shows that there has been a discipline or an understanding of competition policies, so that is part of the existing customs union.
Could I just broaden this to what may happen with us as opposed to Turkey, because I'm not an expert on Turkey. But clearly, you're sort of driving at the idea that would the regulatory standards be maintained if we left the EU but we kept a customs union? Personally, I think that's a slightly separate problem or a slightly separate issue, depending on how you look at it. If you look at the political declaration now on the future relationship between the United Kingdom and the EU, there is quite a lot in there about regulatory alignment. It covers environmental, social, all sorts of regulations like that. And the rationalisation for it within the political declaration is to have a fair trade, fair competition. You don't have an unfair level, you have a level playing field. So I think one thing is to actually negotiate the customs union if that's what was wanted. Personally, as you gather, I would not want that. And the second thing is, when we get to negotiating the future relationship, if we ever get beyond the withdrawal agreement, so to speak, what sort of regulatory alignment would be in there? I think they're two slightly different issues.
Okay. Let me just, in the time I have, thank you for that, just turn to this question of the border. If the point of this, from Turkey's point of view, and it certainly would be from the UK's point of view, is this idea of frictionless trade. We made a visit to the port of Dover, I don't know when, about a year ago, maybe more, and we saw this seamless, massive ballet, if you like, of the trucks coming off the ferries with minimal checks and so on. And the government's aim, I think, is to maintain that as much as possible. But in previous evidence, we have heard, it might even have been evidence from you, Dr. Artıran, that there are sometimes significant delays for trucks at the border between Turkey and the EU. If Turkey's in a customs union, in large part to facilitate ease of trade between Turkey and the rest of the EU, why are there truck delays at the border, and what do you do about that?
I remember your question previous time, and that's exactly the point. Now, I mean, Turkey and some of the EU member states with whom we have problems, for instance, Bulgaria, they are trying to negotiate with Greece. Why, we're having this problem, we have to get rid of it. The answer is simple. Actually, because in that, policy area for road transportation, the European Commission does not have the authority to negotiate. So the member states keep their independence. How to regulate the road transportation, that's where the problem arises. The Commission has good intentions, the EU in general has good intentions, and we all know what the problem is about and everybody wants to solve. But to the extent this policy will remain within the independent policies of the member state, there's nothing much we can do. So that has to be regulated at the Commission level, at the Brussels level, so that the authority of the member state, independent authority, will be transferred to a certain extent to the Commission, to the European Union, because otherwise that is really a friction, even though the countries may have good intentions, but in reality, yes, your trucks are unfortunately stuck on the road.
Give us a picture of what this looks like for a truck driver approaching the border. How long might they be delayed there?
Well, I mean, last time I remember you had asked the same question and I said 3 days. I heard sometimes it's even longer, sometimes it's shorter. I don't think there's an harmonious length to how long you're waiting.
And the implication in your previous answer was this truck that might be delayed for 2 or 3 days or even longer, Turkey's desired remedy for that is to appeal to the European Commission and to Brussels to sort out the delays.
We did to the European Court of Justice.
You appealed to the European Court. So your ally in this, in order to prevent the delays at the border, is the European Court of Justice. That's who you're appealing to from outside the EU.
Exactly. I mean, I remember saying this already, 2 years ago. What you can do actually, Turkey, because we're not a member of the European Union, we don't have direct access to the European Court of Justice. But what is being done in those kind of, problems, the European company who is doing business with the Turkish company has a legal standing before the European Court of Justice. So those European companies, because they suffer out of their business friction with Turkish companies, they brought the case to the European Court of Justice, and the European Court of Justice said that this is not acceptable. Even though Turkey is not a member of the European Union, it just has a customs union.
Yes.
That customs union also necessitates the European Union to provide frictionless trade to Turkey. So it is approved now. I mean, I think this is a settled case. This is now a precedent. I think, that is something that the European Union has to address.
So for a country in a customs union with the EU, but outside the EU in terms of membership, the guarantor of frictionless free trade for that country is the ECJ.
Although I think it does depend on the nature of the relationship. So if we assume that the UK-EU future relationship is going to be quite expansive, so customs union might be one pillar of it, we'd assume there's a pillar on services, probably unless we accept freedom of movement doesn't go much further than GATS. But then there's another pillar on research cooperation, on home affairs and the like. And sitting above that would be some sort of institutional architecture where we would continue the dialogue and bring complaints. So in that circumstance, you could see that body there being where you first brought this issue rather than the ECJ, but this is very much dependent. This is a hypothetical.
That's a hypothetical. And then, I'm talking about the actual existing world.
But then in the issue on the border, the other issue you have, I suppose, is on sanitary and phytosanitary issues, and this is an issue for Turkey, in that if you're outside of the European Union and you send a product of animal origin into the European Union, it has to enter via a veterinary border inspection post where physical inspections are carried out up to a rate of 50%. That can be reduced by agreement, and then also document checks and identity checks are carried out. So unless we are within the SPS area of the EU, including for imports from third countries, those checks, whilst they can be reduced in the terms of frequency, cannot be avoided.
Can I just compliment on
what I'm saying?
I'm being
encouraged to.
Just very quickly. Very quick point again. I don't know very much about Turkey, but I do know about the United Kingdom. And it's interesting that when it comes to this problem of frictionless borders, that both the HMRC and indeed the Port of Calais have said that even in the case of a no deal, never mind about not being in the customs union, if in the case of a no deal, they would actually prioritise fluidity of trade over compliance. They have said that because they realise it's in their interests to keep frictionless trade or to minimise the frictions of trade across the borders, even in the case of no deal.
If they're the deciding authority.
As I say, I'm not an expert on Turkey.
Now, this is... Joanna, just a quick question.
That's very interesting, but that is a unilateral guarantee on the British side. There's no guarantee on the EU side that degree of frictionless trade will be guaranteed, is there?
Well, believe me, I think actually didn't someone come from the Port of Calais and give you evidence at some point? Well,
the question I'm asking you is, I'm not talking about an individual from the Port of Calais, I'm talking about the rules and regulations of the European Union. You're saying that certain people in the UK have given a guarantee that they would do their best to maintain frictionless trade on the UK side of the border. What I'm putting to you is that there has been no matching guarantee from the European Union, because there can't be, because that would be in violation of their law.
I think my understanding is that obviously they've come out with some no-deal preparation documentation within the Commission, and they have made it very clear that they wish to continue with trade. Obviously, you can't talk about guarantees, but I'm talking about the pragmatic.
But they haven't given any guarantee that they would set aside the law of the European Union, have they?
They have made it, I think, fairly clear that they want to continue with the trade and with a good relationship with trade with the United Kingdom. And that, for me, even in a no-deal circumstance, so I think they've made it abundantly clear that they actually want to continue.
See, I would disagree with you because they talked about short-term solutions. What I'm asking you about is the law. There has been no guarantee from the European Union that they would put aside their rules and regulations because in law they could not give such a guarantee. Is that not the case?
Well, I think with under WTO rules, if they started to discriminate against our trade, especially if our regulations were pretty compliant with the EU trade, they would actually be hauled over the coals in the WTO and said they were infringing the WTO.
But I see others shaking their heads. What puzzles me about how you feel that you can say that is that the European Union is already a customs union and a single market, which by definition applies different rules and regulations to third parties. I don't see the WTO have any problem with that at present, do they? I'd no doubt be corrected by these other experts if I'm wrong.
Just briefly, I suppose the question is, can someone at the Port of Calais set aside the rules of the European Union when it comes to checking goods coming in from third countries? What's the answer to that?
No.
No.
And we should also be careful when people representing ports speak, because they are competing with each other for business. So there is a necessity to talk up your ability to deal with additional friction at the border in order to avoid diversion. And on the WTO front, of course not. If we are a third country, the EU should treat us as they do every other third country. And actually they're less likely to get into trouble for actually being mean to us as they are to being too nice.
Is that your view too, Mr. Henning?
Yes.
It is. Okay, fine. Now, did you have a very quick question before I bring John Whittingdale in, John? Richard?
Very quick question on this, Chairman, which was related to the answers you've both given. I mean, David Henning, we heard from John Thompson, the head of HMRC, when we asked him questions around this issue. His answer was effectively, you are asking me to look into the mind of President Macron to understand his instructions to the customs organisation. Is your basic belief that if we want to have as much frictionless trade as possible from Dover to Calais and beyond, that it has to be done within the structure of an arrangement of some form or another, and that just assuming that if we left without a deal, that somehow this could all be patched up between Dover and Calais is very optimistic?
A short answer will do.
I think that's right. I mean, my view is that if you were to leave with no deal, a customs arrangement between the UK and the EU would be the first arrangement, practically, that you would want to put in place in order to address this. But clearly there is occasionally some discretion, as we saw in France when there was the work to rule recently on Eurostar. There was clearly some discretion between the maximum level of checks that they're going to do and the minimum. But there is a basic level that has to be done within the law, and we would want that arrangement to minimise the checks and minimise the delays were we to have no other agreement.
Okay,
Very small thing perhaps. Under Article 5 of the GATT, the General Agreement on Tariffs and Trade, there's a freedom of transit. And actually recently the WTO panel decided between a conflict between Russia and Ukraine when there was a problem of shipping or sending products. So in case the worst scenario happens, under the GATT norms there is the freedom of transit. So you have your trading partners have to facilitate your shipping goods or your transiting, but you wouldn't like to stay with the WTO norms. You would like to have a preferential deal, of course, with the European Union. That should be only the last case scenario, I would say.
Okay.
Under the trade facilitation agreement, also under the World Trade Organization, you can also try to secure the passage of your products.
Thank you. John Whittingdale.
Thank you. Can I come back to a couple of points that have been raised? Firstly, following up Craig McKinley's questions about Article 24. As I understand your answers, accepting the limitations that Article 24 only applies to goods, it only applies to customs arrangements, and therefore not sort of regulatory obligations, etc., that it has to be temporary and it needs the agreement of the other side, in other words, the European Union. Accepting all those four things, all of you see no insuperable obstacle to an agreement under Article 24.
That's Sorry, to be clear, there are different arrangements that are possible within Article 24. A customs union, an interim trade agreement and a full free trade agreement are all possible Article 24 compliant agreements. But there is no... The WTO, as long as you follow the basic set of rules, that's fine.
Right, excellent. And as I understand it, the arrangements with Turkey were covered by an interim agreement under Article 24 prior to the signature of the customs union agreement, and that lasted for 22 years. Is that correct?
Well, yes. I mean, this is the argument put forward by the European communities and Turkey in the older GATT documents before the establishment of the World Trade Organization. So the relationship started in 1963 and it lasted quite a long time because the real customs union decision was able to be signed only in 1994, which entered into force in 1995. So it's quite a bit of, long time.
22 years.
Exactly. So, but, in the meantime, there was no World Trade Organization. World Trade Organization was established in 1994, so which means actually throughout 1963, the signing of the Ankara Association Agreement until 1994, the GATT rules perhaps accommodate in a quieter or more convenient manner those interim agreements. But perhaps this time, this time of the time with the World Trade Organization, perhaps it will not work this way. And when you look at the records, there are not many interim agreements actually which are being notified to the World Trade Organization as it exists today.
Just on that point, I know Mr. Lowe wants to come out, but on that point, the EU is in the process of negotiation of FTAs with a number of countries, Mercosur and Australia. Are there Article 24 arrangements in place for any of the current negotiations?
Well, so all of those agreements will be negotiated under Article 24 and be Article 24 compliant, because Article 24 is a big, that's what you use to negotiate. What I'm asking is whether or not the interim,
precisely.
Not on the ones you've mentioned, but I'm not going to rule out that it hasn't been used at all, because I don't know the answer to that. When it comes to other agreements, one point I would make about the UK-EU relationship is there's reasons not to want to rely on the interim arrangements as proposed by Article 24 within GATT, in that if you go that route, you have to notify other WTO members and they can object. So the actual rationale for how the EU and UK currently are approaching it, which is we have this transition agreement which performs the same function and keeps everything the same, but it is in essence just another agreement, but it's time limited. It means you avoid all of that. You're not bringing in other countries to opine on what you're doing. It's just dealt with bilaterally. And that's one of the reasons why interim agreements are quite rare, because you don't necessarily want everyone else interfering with your bilateral negotiation with a single country.
I see. Ms. Lowe, you also said that being a member of the Customs Union did not prevent you reaching your own trade agreements outside the terms of the Customs Union, in other words, in areas such as services or any intellectual property, I think was the other area mentioned. But it would prevent us offering anything in terms of goods access beyond that covered within the existing customs union. That's correct.
Yes. So absolutely. So, and also just to be more explicit, we would, if we are in a customs union with the EU and the EU chooses not to do a trade agreement with, say, India, the US, China, or the like, we would not be able to do a comprehensive trade agreement with them, with those countries either. So we are bound to follow the commercial policy of the EU. So, but I'm talking about comprehensive trade agreements. But were we to decide we wanted to do, so say, have a regulatory dialogue on financial services with the US, that would be something that we were perfectly able to do within a customs union as a member of the UK, whereas we would not have been able to do that necessarily when we were an EU member, or would have at least had to take on a different form.
So if there is a agreement between the EU and a third country, then we are bound by the provisions of that agreement. If there isn't, we can reach bilateral arrangements, but not in those areas which might be covered.
So we are bound, but only specifically on tariffs. We are bound specifically on tariff levels, and I would argue that with the UK relative to Turkey, there is a greater incentive to negotiate with the UK, just because we have a richer consumer market, and the direct access when it comes to lower tariffs will prove important. And I think it's also important to look at the counterfactual. So who is the EU negotiating with right now? So Australia, New Zealand are now on the cards. Those are countries we'd like to do an agreement with if we were outside. So those agreements look like they're on the cards even if we're in a customs union or not. If we go to the US, will we be able to do an agreement with the US if we were outside of a customs union, whereas the EU couldn't? Maybe. I'm not convinced necessarily that the British public are as pro a US agreement as we might like them to be. We will see. Will we be able to do one with India? No. No one does trade agreements with India. Until New Zealand manages, I'm not going to be convinced we could. With China, perhaps, but then you do have this conflict, whereas because Switzerland managed to do an agreement with China, Iceland managed to do an agreement with China, so could we? Yes, potentially. But then you have this conflict whereby the US in their most recent agreements have specified that if you do an agreement with China, they're going to have some issues with their agreement with you. So you're put in this awkward situation of having to choose. And I would also mention that, say, the Swiss agreement with China is quite lopsided. So does leaving a customs union grant you some new opportunities? Yes, possibly. I would argue they're not as wide as people might argue. But then you also then have to look at what is the trade-off. What's the economic benefit of these new agreements versus us being in a customs union? As it stands, there's no economic evidence to suggest that the new free trade agreements will compensate for the losses of leaving a customs union. There are potentially political rewards in that you can announce to the public that we have a new free trade agreement with the US and it makes good headlines. From an economic perspective, less so.
May I perhaps comment on that? I have a slightly different view compared to Sam's view, because in Turkey's experience at least, because we are not part of the EU's customs union, we have a customs union, separate customs union with the European Union, and that customs union has given the authority to the European Union to negotiate all of the trade deals. Yes, if I'm concluding just a services deal, I may do it because my customs union only regulates, trade in goods, but no country just, signs a services deal. Normally what you start with is an agreement in trade in goods. So the experience of Turkey, and it's stipulated in the documents, legal texts, which are binding Turkey and the European Union, and also to a certain extent that derives from the interpretation of Article 24 of the GATT, you unfortunately do not have an authority to sign independently a trade deal unless you have a different institutional framework. And this is where Turkey-EU customs union is not perhaps the best example, and that's why we are trying to actually modernize that agreement, because within the institutional framework, Turkey does not have a seat in when an agreement is going to be signed with a third country, whether Turkey will have a seat when the agreement is being negotiated. So while you're trying to sign your customs union agreement, or when the Turkey-EU customs union is being modernized, that's the first thing which needs to be done, because you are the taker of a decision. So you're decision taker, agreement taker, but you're not effectively contributing to that agreement. It is stipulated that the parties have to consult each other, but that does not work really well in practice. So that's some of the things that you need to take into account while you're drafting your own agreement.
I mean, I'm listening to you saying that Turkey doesn't have a seat at the table. It is signed up without having any ability to influence the deals, which may not actually be in its interests. You say to Mr. McFadden that drivers are sitting for 3 days queuing at the border. One has to sort of ask the question, what's in it for Turkey? I mean, this doesn't sound to be a terribly beneficial arrangement as it's working at present.
No, of course, when you look at it this way, it may not look best, but at the same time, you have to give credit to the European Union that normally it signs agreements with countries when it makes sense to do trade. So Turkey having a customs union with the European Union and knowing that the European Union select those countries which are beneficial to have a trade agreement, I don't think that, that negative scenario actually happens. Having an agreement with, with Japan, having an agreement with Singapore, with, Korea, etc., South Korea, these are all nice countries to have a trade agreement. The only problem is that the threshold is so high when the European Union negotiates that agreement. It may be hard for you to come behind. Nonetheless, I think Turkey has shown a good record of signing agreements with third countries, only with some of them which we had really problems, whereas for instance Algeria, I keep saying Turkey has a huge interest in Algeria for having a trade agreement, but once Algeria signed the trade agreement with the EU, they had no interest whatsoever to sign a trade agreement with Turkey. So these examples exist, but it all depends on, again, I will repeat many times, you have to set the right institutional framework and you have to be within the decision-making table, not the decision taker.
Oh, you've been trying to come in, so why don't you go first?
Well, I'll just make some very general points here because I know we're getting into a lot of detail here. Obviously, we know that one of the reasons I want to leave the customs union is to obviously negotiate trade deals with third countries. And I think that makes an awful lot of sense from an economist's point of view, because what you want to do is realign your trade with the fast-growing parts of the world. And within a customs union, we can't do that. And it's actually interesting to note that even where we are now, that our trade with non-EU countries is growing quicker than with EU countries, because, of course, it's the commercial realities that tend to drive trade rather than the allure of a customs union or the single market. So I'm very strongly in favour, leaving the customs union, realigning our trade with the fast-growing parts of the world. And I would just like to take issue with one of my colleagues here who was saying there would be no overall advantage to doing that, because there is some economic analysis from Economics for Free Trade, for example, which suggests that if we did that, we could actually have 4% of GDP over the next 15 years. Now, of course, those figures are contentious. Economic analysis is always contentious, but it's pointing in the right direction, that if you push towards fast-growing parts of the world, then that will benefit your economy. I mean, there's the other thing to say about being in a customs union, that we can't actually change our tariffs. So if you want to cut tariffs on food produce or clothing or something like this for various reasons, you can't do it. And I think very quickly, the other point I would like to make is that customs unions, because they're about goods, benefit goods-weighted economies. So not service-weighted economies. And of course, we're a service-weighted economy. And if you look at Germany, when they look at the proportion of goods to goods and services, in Germany it's 82%. 82%, nearly all of their exports are goods. With ours, it's just over 55% is actually goods over goods and services. Moreover, the services proportion is rising because that's where we have the comparative advantage. And of course, the customs union can't do anything about that. But the customs union, as I think has already been said, would stop us from able to do comprehensive trade deals with third countries. Okay, you might say, well, customs union doesn't about goods. We can still negotiate about services. But why on earth should a country like India or the United States of America actually open up their markets to our services when we will not open up our markets to their goods? It just doesn't make sense. So I think the idea of trying to have any sort of reasonable customs union, any sort of reasonable trade deals with third countries when you're in the customs union, I think you can frankly forget it. I think it's a non-starter. So, I mean, this is a plea from me not to continue with the customs union, but actually to grab the opportunities of free trade going ahead as the world economy is developing.
Sorry. I was going to come in just a couple of points briefly. Thank you. So Turkish business, and I've spent a little bit of time talking to Turkish business, both when I was part of the TTIP negotiations and more recently after the Brexit vote. And they absolutely say that the customs union is really terrible, it's really badly structured, and it's absolutely the worst thing, except for not having an agreement would be even worse. So that is coming straight from what they have said. In terms of services, because I think this does come up, because we talk a lot about the fact that the UK is a services-dominated economy. In fact, in terms of exports, it's about 50-50. Yes, there are a few services-only agreements, free trade agreements, not that it's not possible, but equally within free trade agreements, it's actually very difficult to liberalise services as well, and you generally find there's not a huge amount of services liberalisation. Now, if we look at the areas where the UK is particularly strong in terms of services, financial services, business services, generally those companies are not actually relying on trade agreements at all to trade around the world. They are finding ways in which they can trade, whether that's setting up subsidiaries or whatever it is. So I think that if we're having a conversation about services trade, I think the starting point of the conversation would not be what free trade agreements can you have. The starting point would be what is it that they're currently experiencing in terms of barriers, and how do you overcome them? And I don't think trade agreements would be the first answer you'd come to.
Now, hang on. No, hang on. Mr. Lowe indicated next, and I know Jonathan Ginogly wants to... Actually, why don't you ask your question?
I'm sort of agreeing with what David Hennig has just said, because I think there are dangers in too closely comparing the British and Turkish experiences, because our economies are very different. But I do think it does lead us to say that we need to look to see where our economy might be heading as to what sort of deals we want to do. And if we are going to continue along the course of becoming a more services-orientated economy, then we might not be so bothered about not being able to have competitive advantage in terms of on a customs deal. But I'd just be interested to know what percentage of services are exported in Turkey. It's presumably quite low.
Well, I think you have a perfectly point, but I just wanted to say at the beginning that I perfectly agree with David. You know, when you ask business people today in Turkey, many people nonetheless would like to have a customs union. Yes, it is old now. It was signed in 1995. It needs a revamp, like many things, like even the WTO is being reforming itself. So, but if an FTA is never an alternative to the customs union, because we have changed so much the structure of the Turkish economy by aligning ourselves with the regulations, by producing products in accordance with the EU standards, and so did you. So for many years, you actually produce your products in accordance with the EU rules and regulations. So leaving this aside now and having an FTA is not beneficial. Yes, the existing customs union is not enough, but believe me, I think there is an understanding in Turkey which is shared by many, including our foreign counterparts like Euro Chambers, Business Europe, etc. They say this customs union has to go on and it has to be revamped.
So we're in danger, that's my point, that we're in danger here of talking about what we have rather than what we want to have.
Yeah.
Now, Mr. Lowe.
So to come back to a couple of points in terms of what could the UK offer whilst in a customs union in order to get market access if it's not able to unilaterally play around with its tariffs. Well, I can give you one recent example, actually. So universities, when a foreign student comes to a British university, that is classed as an export. It is a services export under Mode 2 of GATS. One thing we could do right now, if we wanted to, is allow foreign students to stay for another 2 years to find a job. That would help out our universities industry, it would help out our services exports. What else could we do? We could do a lot more when it comes to visas, when it comes to intra-corporate transfers, when it comes to business visitors. If we want to talk to India, that's what's going to be on the table more than tariffs regardless. When it comes to assessing whether future free trade agreements will offset the economic impacts of whatever type of Brexit we have to be careful, because free trade agreements really do not do very much for aggregate GDP. At an aggregate level, we are talking about rounding errors. Beneath the aggregate, you might see huge shifts in the structures of businesses and where they sit in the economy. And there might be knock-on productivity effects and the like, but we're actually very bad at productivity and working out what impacts what. And when it comes to the economies for free trade estimates, I would emphasise that, yes, it is true that all models have to be taken with caution, but that one has to be taken with a lot of caution because it assumes that EU-UK trade will continue as now, no matter what. So everything else is just a positive because it assumes no negatives. If you look at the government figures, you see that the predicted future free trade agreements, the benefit is around 0.3%. That's maybe a bit low, but it's in the ballpark. If you think about EU-Canada, the upper estimates for that was that it would benefit the EU economy by 0.04 or 3%. So we're talking small numbers. But then when you look at the negative impact of leaving a customs union, it mixes up two things in the estimate. So it mixes up customs forms and rules of origin, and it comes to about 1.7%. If you assume that half of that is the customs forms, which would remain even if you're in a customs union, you're still at half of 1.7 as 0.85 as the impacts of rules of origin. And that's what you're trying to surpass with your future free trade agreements. And as I also mentioned earlier, there is no guarantee we would actually get these trade agreements that the EU isn't going to get. So whilst I think, yes, customs union comes with constraints, we have to be very realistic about what the alternatives are.
Okay, now Stephen Timms is coming in next.
Dr. Artıran, you've made it clear to us that Turkey, as I understand it, has no influence at all over EU trade policy consequent on its membership of the or participation in this customs union. What I'm wondering is, the UK is very different, it's a major trading economy. Do you think that would allow the UK to gain influence over EU policy if it had an arrangement along the lines of the Turkish?
Thank you very much. I mean, first of all, there are some committees, within the Turkey-EU, bilateral, trade relations, such as, joint committees, association councils, which are supposed to meet every 2 years. But what I'm thinking for the United Kingdom is that there's an experience which has been done with Turkey. So both parties have said, at stages that they were not happy with the customs union, mainly at Turkey's side, because Turkey was not able to take part. And I think the European Union heard about all of these complaints, and the revamped customs union actually could offer some new positions, some new possibilities that these joint committees would actually work in practice, so that Turkey could be part of at least decision shaping. Not perhaps decision making, but if it can be part of the decision shaping, I think it's a good start. So while we were talking about all of these, revamping the customs union, those possibilities were on the table. So what I'm thinking about the United Kingdom, drawing on the experience of Turkey-EU customs union, I think EU might offer indeed, some possibilities to the United Kingdom, which needs to be discussed. But again, I will agree with Sam. If this is being offered to the United Kingdom, I think Turkey, and rightfully so, will ask the same possibilities for the revamped customs union, or any country, San Marino, Andorra, would also ask the same thing. So it will form a precedent for the European Union if they let you be part of the decision making or shaping, whatever you name it. So you will be a precedent, actually.
Okay. Mr. Henning, Mr. Lowe, any comment on?
I agree with that. I mean, there's willingness on the Commission side. They've already been talking about giving Turkey a say. They haven't quite worked out what that will be. So there is willingness. I mean, I'm thinking in terms of current, UK at the moment has some say in EU committees, but the Commission basically runs the show. It's up to us as to how much influence we take at the moment, and I think in a new environment, yes, there would be formal structures. It's also going to be down to the informal ways in which we seek to have influence on what it is we're trying to achieve. And I think that would be the key question, really, is, again, in terms of these trade agreements, what is it we would want from the EU in this scenario? And I think we'd have to work pretty hard to know that.
Okay. So I would list some of the things. So it would be a greater commitment from the EU to pressurise the third countries they're negotiating with to also negotiate with the UK in parallel. It would be consultation as to when these negotiations were going to begin, so we could do so in parallel. Also, consultation when it came to the implementation of said agreements, so that we could align ourselves there. And could the UK achieve this? If we go off what the Commission says, certainly, and I think different people in the UK have spoken to the Commission about this. The issue when it comes to Turkey has always been the Member States. It's the Member States that have blocked upgrading the Turkey Customs Union for political reasons that are divorced from trade. So there's lots of other issues between the EU and Turkey. So is it possible? Yes. I think where I draw the line is that where I can see that the effective consultation mechanism could be created and it could be institutionalised, the UK would never be in a place where we would have a veto over the EU's trade agreements. Because let's be clear, they are still the EU's trade agreements. The ones we would do whilst in the customs union are still our trade agreements, and there still is that distinction. And EU member states do not have a veto necessarily over EU trade matters. So the UK as a non-EU member state, a non-EU member would not be able to. Can I just
compliment on that? Because in the Turkey's experience, there was a Turkey clause that the European Union was putting actually in the agreements that it was signing with third countries. So that Turkey clause would try to make sure that that country which signs a trade agreement with the EU would need to sign a trade agreement with Turkey as well. But I think this clause is not very helpful, because after all, you're dealing with an independent state. You can't force a state. But one of the proposals which was on the table, and perhaps the UK can also discuss, what if the European Commission negotiates a free trade agreement on behalf of the customs union? Not only itself, the EU, but also the customs union with the United Kingdom. So if this could be done legally, and if this does not, bother you as an independent state, that the Commission, negotiates a trade agreement on your behalf as well, I think this could be a solution.
Okay, interesting. So apart from Turkey, San Marino and Andorra, the EU also has customs arrangements with Jersey, Guernsey and the Isle of Man. Is it right to describe those as custom unions as well, or is that something else? Could there be advantages, disadvantages to the UK aiming for that kind of arrangement rather than something that looks a bit like Turkey, San Marino and Andorra?
So this feels like a question to me as I've written about this quite a lot. So Jersey is a very interesting case in that it's not a member of the UK, it's not a member of the EU, yet it's in the EU customs union, the EU customs union, and de facto the single market for goods. So if you think about the relationship Jersey has with the EU now, it's what the Northern Irish specific elements of the backstop would look like, pretty much, in terms of its customs union, single market for goods, with a few exceptions in that it doesn't. Jersey's not included within VAT, but it is a unique case in that the reason this relationship exists is because of the UK's accession treaty to the EU, where the Channel Islands, the Isle of Man, was carved out. But do I think the precedent of being in a customs union and single market for goods is one that the UK should look at? I would say yes, insofar as if you beef it up to the extent that we've seen for the Northern Ireland specific elements of the backstop, you can have frictionless goods trade. The big reason why the EU wouldn't go along with it is that it is very clearly splitting up the four freedoms. And if we were to ask for that without freedom of movement, there would certainly be a problem in that the Swiss are effectively single market for goods, not customs union, but single market for goods with some exceptions, and they have to have freedom of movement. So do I think, as someone who has mentioned, I refer to it as the Jersey option, as someone who's put it forward, that it's something we should think about? Yes, but I'm under no illusion that it would be an easy thing to achieve.
Okay. Thank you very much. Peter Grant.
Thank you, Chair. I want to first of all come back to Ruth Lee about your enthusiasm for leaving the customs union. The only land border the United Kingdom has got is an island. At the moment that is an international border, it's not a customs border. If Northern Ireland leaves the customs union, then as a matter of fact and a matter of law, the border on Ireland becomes a customs border. How would you propose to manage that customs border?
I think there was a Dutch customs expert, that I think he might have given evidence to this committee.
Can you just speak up?
I was going to say,
the acoustics are rather poor in here.
A Dutch expert, Mr. Messen, did he not give advice to this committee? I think he did. Well, however, and he was saying that there was no reason why you shouldn't have electronic declaration of customs forms, as indeed with presumably there's a tax border already with Northern Ireland, VAT and excise duties and the like, and a trusted trader scheme, possibly using customs advisors, and then off-site, off-border inspections. And he seemed to think that that would work perfectly well. And I was very impressed recently that Mr. Varadkar, who's of course the Irish Taoiseach, said that under no circumstances did he see the need for a hard border in Ireland, which I thought was quite accommodating, considering he's sort of equivocated about that. And indeed Barnier was implying the same. So it does strike me that if you talk to people like Messen or you read the stuff that Messen has been doing, there is no reason why there shouldn't be a solution to this. And it was interesting too that I think you see John Thompson, who's the head of the HMRC, he on at least a couple of occasions to one of the select committees has said that he sees really no need for any extra infrastructure when it comes to the actual customs declarations across the Irish border. I just quote these people because they are the customs experts, not I.
You may know that Pascal Lamy was pretty dismissive of some of the comments that you've quoted there just now on Politics Live the other day, but can I press you on this kind of off-site verification and whatnot? What stops somebody from just crossing the border with a truckload of goods that they haven't registered anywhere? They're not a trusted trader. What is there to stop not trusted traders crossing the border? What is there to stop somebody from crossing the border and not bothering to go to a checkpoint somewhere else?
The truth is that there will be the usual checks that happen already. There are already checks when it comes to excise duties. There is already some smuggling across the border, and the HMRC has to deal with it accordingly. So the checks will have to be there. I'm not disputing that, but this is not insuperable.
Can I ask if you've actually been to the border?
Sorry?
Have you been to the border to see these checks?
No, I've not. No.
Yeah, because when we went to the border, when we went to the Irish border,
if I may say so, I think that the whole border is being, blown out of proportion, so to speak, because I think the solutions are there with goodwill and cooperation and the electronic availability that is already there. And that was the evidence of a customs expert. As I say, I'm not a customs expert, but I just take the advice from customs experts.
So why then is the official position of the United Kingdom that the means do not yet exist, and they don't know when the means will exist, to have a customs border in Ireland that complies with the terms of the Belfast Agreement? Because we're not talking about a border, a porous border such as the Swiss border, for example. The limited checks that exist at the Swiss border are not allowed at the Irish border. The limited checks that exist on some of the border crossings between Canada and the USA would not be allowed under the...
I think it's most dispiriting that we can't assume that there will be cooperation between the Irish and the Northern Irish to actually solve the problems of the customs border. I really find that very dispiriting.
What exactly is it you're suggesting?
Can I just repeat? I am not a customs expert. I have offered you the best knowledge that I have, and under those circumstances, I do think that the customs border is not an insuperable problem, which is apparently what Mr. Varadkar is now saying. So I can't say anything else to you.
Can I finish then by asking, you've described yourself as not a customs expert. How much weight, therefore, should this committee give to the evidence you've given about the benefits of leaving a customs union if you describe yourself as not being a customs expert?
I'm an economist. I'm not a customs expert. And I look at the economics of this, and as I was saying to Mr. Whittingdale, if you are interested in the economic future of this country, you need to align with the future developments, not the past. And I would just say to David, too, that when he was talking about services agreements, he is talking about the present, he's not talking about the future. And, of course, the WTO is pushing for trade deals on services. So I will say this to you, I'm an economist. As far as I'm concerned, I have looked at the evidence from customs experts. The Northern Irish border is a soluble problem. As far as the economics are concerned, I have little doubt that being outside the customs union and pushing forward with our own trade deals, our own commercial policy, is actually the sensible way forward.
Thank you. Some of the other panel members wanted to come in and parts of that, so with your permission, Chair, I'll give them a chance to come in.
Is that okay? Yes. So on the sort of proposals for Northern Ireland that are on the technical or technological route, I think you hit on the point entirely, in that I can come up with a solution that works for those companies and people that play by the rules, in that you pre-notify what you're going to be sending across the border. It goes through some risk management system. If there's a problem, you get a notification, you have to stop off somewhere on the way, and they do a check. This is just on the customs side. I'm not talking about regulatory side, especially not on the sanitary and phytosanitary issue. But how do you manage those people and businesses that decide, I'm just not going to play by these rules at all? And the answer is stop and search. So you have random stop and searches, what you need anyway to keep the system honest, and then intelligence-based policing, so raids on warehouses. And no one has actually made a convincing argument, at least to me, why that is preferable to actual stops on the border when it comes to a stability point of view. In that these investigations, these checks do happen to a small degree now because of VAT and excise, that is true, but we would have to increase the magnitude of them by quite a lot. And I think people approach the Northern Ireland border issue wrongly sometimes, and they miss what actually the commitment is. The commitment is no physical infrastructure or associated checks. That second bit is important. And actually the physical infrastructure is a symptom of the problem, which is you have created an economic border between Northern Ireland and Ireland where, as before, there was not one. And the physical infrastructure is the visible implication of doing so. And the backstop is pretty much manages to achieve a situation where nothing changes. Every other solution we're talking about that doesn't involve integration to that degree is about accepting there is an economic border and trying to mitigate it. But at that point, my fear is that the damage has already been done.
Thank you.
So, I was just going to come back because there was a quick mention on services. Yes, there is or there was a trade and services negotiation at the WTO. It is currently stalled. One option for the UK would actually be to try to unstick that, or even to create our own option of a services agreement. These are things that we could do, but I don't think, we don't hear enough about it. We hear far too much, if you don't mind me saying, about the Irish border, and far too little about services trade and what we could actually do.
Okay. Right. Now, I think Stephen Crabb wanted to come in on the back of this.
I'd like to follow up on Peter's questions about the Northern Ireland border, and if I can direct my questions in the first instance to David Hennig and Sam Lowe. Both of you in your commentaries and your writings elsewhere express some frustration at politicians who want to chase after fantasies in regards to Brexit, particularly with solutions for the border. I think yesterday on social media you both expressed some scepticism around a new working group that's being convened to look at alternative arrangements. What do you regard as the real-world practical discussion and inquiry that needs to happen around alternative arrangements? Because that phrase does appear in the withdrawal agreement. What is the real-world discussion that needs to happen on these arrangements, and what would you be counselling politicians to avoid looking at if they want to keep their feet on the ground in this?
Okay, so this is a slight reprise of something I had a long session with the Northern Ireland Committee, where what I said there was I regard myself as quite optimistic on the Northern Ireland border. I believe that there could be solutions. It's just that they're unlikely to be in place by tomorrow or next week. Let's change the question around. Instead of saying how do we keep a border, we could say how do we become the first country that is not an EU member to have no external border infrastructure with the EU. So we would be a pioneer. There is no country in the world that does this. So to be a pioneer, what is this going to be about? It's not about, borders are not really about law-abiding traders who are going to do this already. This is going to be about the trust on both sides of the border, that all procedures are being kept to, and that the penalties for non-compliance are so high that everybody actually complies. How long does it take to create that kind of system that is underpinned by technology, a whole heap of processes, mutual trust, security? In my experience, and before I was working in trade, many years ago I used to work in IT systems, these are the kind of things that IT systems take 5-10 years to do, supported by changes to process. What we've got to recall is that at the moment on the border is the sort of the backstop, if you like, for all of a lot of different arrangements where they are customs, they are whether legal or illegal goods. The border is the only place where the goods, the paperwork, the driver all come together. It's the only place you can inspect it. If that's going to change, you need to rethink how the whole system works. That will take time. So my advice, and going back to the question, is let's be realistic about this. This is a huge challenge. Could it be achieved? I see no reason why it shouldn't be achievable, but I don't think it will be easy.
Well, just going to say that Mr. Messenfort is he did suggest that it would take perhaps 21 months to implement the sort of checks that he was looking for. And as I was saying, as far as John Thompson was concerned, he didn't see the need for any further infrastructure on the actual customs declarations. And could I just point out that you talk about a border, we've already got a border, I've already said that, there's already a tax border between the Irish Republic and the United Kingdom. So we mustn't forget there's already a border there, and the customs has to deal with it, and it does deal with people who transgress the rules on an intelligence-based system, as the customs functions. In any case, they function on an intelligence-based system. So as far as I can see, it is not an insuperable problem, but obviously does need looking at.
Sam?
I think we should always be careful about assuming that just because a certain level of intrusion is accepted now, that increased levels of intrusion will not cause problems in the future. And of course, I'm not saying government policy should be dictated by this, but I am saying that if you are looking at a post-conflict region of the UK, you should tread carefully. And that's why I'm not convinced necessarily that increasing the level of intelligence-based checks, surveillance and random checks around that area will be conducive to a stable Northern Ireland. And I might be wrong about that, but that's just my worry. And this is where the backstop comes in, where for all of its flaws, the backstop works. It doesn't lead to any new physical infrastructure or associated checks at that land border. It straddles the lines a bit, and there are still some questions to be asked. As to whether I could envision alternative arrangements coming in the future, perhaps, but it would need to be a part of a process that's in deep consultation with people in the region and that area about what sort of changes would they actually be willing to contemplate. And it's not a binary issue. Lots of people have different opinions where they might like a bit of freedom in a different area, but That's a process. And as to whether this can all be done in 2 years, I think people get hung up on the technology. So one of the So be it the customs expert mentioned or others, they point to single window technology. And this is something the UK should be aspiring to at its own borders anyway, which is that if you are exporting to the UK or exporting out, you send in all your information to one website essentially, and it gets funneled into a load of systems, and then the risk assessment is done on the basis of all the information you've given, and if there's a problem you're asked to go somewhere en route. The issue isn't that the technology doesn't exist. The issue is that it's much harder to implement this if you're in a system like the UK, where we've been around for a very long time, and you're actually going to also have to align government departments. If you think of all the different agencies of government that operate at the border, Border Force, local authorities, HMRC, you have to get them all in line behind this. And I think quite a few of you have been ministers before. You know that cross-government IT systems and projects, the technology might exist, but it still takes quite a long time. So when I'm disparaging on, I suppose, technical solutions, I actually agree with most of the suggestions when it comes to the UK's general external border. My issue with Northern Ireland largely comes back to the how do you deal with the people who don't partake in these systems without a funnel for them to go through where you can weed them out, and me just not being certain that greater intrusion into people's lives in that area is actually any better than having the physical infrastructure in the first place.
Since you mentioned single window, if I may, just a clarification, because this single window, I first came across the idea in 2009 of the single submission of documentation to all the border agencies. In fact, apparently it's been around since at least 2005, and it may possibly be implemented within the next 3 or 4 years. Do the maths, that's about 20 years that it's taken.
Okay. Can I ask one final question, yes, Mr. Chairman? What does the panel think will be the real practical difference it will make to the next stage of Brexit negotiations, having a firmer and more specific commitment to a customs union in a revamped political declaration? Are we talking about something that's largely a cosmetic change here in terms of the dynamics of the negotiations, or actually really does it matter?
It matters insofar as does it mean you and your colleagues vote for the deal? That's how much it matters. The political declaration is not legally binding. It informs the future relationship as it stands. It can already accommodate many different forms of the future relationship, with the exception being because of the withdrawal agreement text. If you want a Canada-style relationship with the EU, you have to accept that's just for Great Britain, and alternative arrangements will be in place for Northern Ireland. But if you want to go deeper, then it accommodates it. So the discussion now about whether the political declaration can be rewritten to more heavily single a customs union is largely for the benefit of the internal politics of the UK, not necessarily what happens with the future negotiations.
Any different views?
Just on a general note on the political declaration, I actually looked at the wording on the customs stuff. And as we know, the political declaration is not legally binding, but it's the foundation for negotiations going forward if we ever get there, if you get my drift. And it sort of said no tariffs, no fees, charges or quantitative restrictions across all sectors, with ambitious customs arrangements that build and improve on the single customs territory provided for in the withdrawal agreement, which obviates the need for checks on rules of origin. That sounds like a customs union to me.
It does, doesn't it?
No, I mean, because if you're talking about rules of origin, we know that the big difference between an FTA and a customs union is with rules of origin.
Okay. Pınar Artıran.
Thank you very much. I want to just ask a little bit about the relationship that we may have with existing EU trade agreements. I think some of the points I was going to raise have already been addressed, but I'm puzzled by this point in relation to the sort of pragmatism around developing new independent free trade agreements with other countries. Currently we have access to 40 plus EU trade agreements covering about 70 nations. That's about 150 billion worth of our imports and exports. What would your expectation or understanding be in practical terms about our access to those trade agreements once we leave the European Union, bearing in mind that we have been part of negotiating them? Do you see there being a future whereby they are easily replicated as independent agreements that we have in some form? And do you think there's a question about scale as well? Currently we negotiate as a block of 500 million. We would be negotiating multiple agreements as a block of 60 million. Is there a question about the sustainability of the economic benefits that would come from such an approach?
I think that's a question. I'll be the first to have a go, and then my colleagues will tell me the bits I've missed out and forgotten. So in terms of the replication of existing agreements, it has not been easy so far. We have a commitment in the case of a no deal that 9 out of the 35 to 40 that are included. And the reason there's a confusion over the numbers is that nobody quite knows whether sort of San Marino and the small agreements are actually included in the number. So, yeah, we have commitment to 9 of them. None of them really with major trading partners. The largest full commitment is from Israel. The agreements with Norway, Switzerland and Iceland are very partial. In the case of no deal, a number of countries have said that they don't wish to replicate. In the case of no deal, what they have already, Japan is the most obvious. And I think that what we've got to bear in mind with the trade negotiation is if we go to another country and say, we would like to replicate this deal you have with the EU, the other country is going to say, well, that's very nice, here's what we would like from this is a negotiation. And so we will not find it easy. I've no intelligence from the Department for International Transport if they're going to international trade. If they're going to use the coming months to try to get more than 9 across the line. But the information I have is that they're finding it more difficult than they were expecting, and that is what I would expect in terms of trade talks. In terms of new partners, I may differ from the common wisdom. I think the common wisdom is that we'll struggle to get as good a deal as the EU. My take on it is that, well, we won't have as many asks potentially as the EU. So if we only have a smaller number of asks, that's all that we will get. I think the question we have at the moment is that we don't know what our asks will be from trade agreements, and I'm still really none the wiser as to what we think the importance of. We've got a list of Australia, New Zealand and the US. I don't know why that list is drawn up. I don't know what in particular we're expecting to get from those countries, and I don't know why other countries wouldn't be considered. And I think we need to do that before we, and that applies also to the replicated agreements. What is it that we're really gaining of value in these agreements? And what you find, Sam was right that the overall aggregate contribution from trade agreements is quite low, but specific areas really benefit from it. The Scotch whisky industry, delighted to say, has been a major gainer from it. They get lots of protection from these agreements. Now, what other areas can we have that gain from them? But the point being, it is a negotiation, and we will find it tricky in all circumstances. But the key is, what is it we're actually doing these for?
Yeah, what I wanted to say actually, also from Turkey's experience, if you are outside the system, if you don't have an agreement with the European Union, of course these third countries find it more interesting to sign an agreement with the EU, because then you have access to 27 countries, and once the agreement with the European Union is signed for the first time, then the threshold is set. The standards already have been set, what kind of market access you can have. Then whatever your agreement you're signing afterwards, actually you're following the footsteps of the agreement that the European Union has signed. And I would like to give perhaps some statistics. For instance, in the example of Tunisia, there's a 7 years time gap between the agreement signature by the European Union and Turkey. For Morocco, 6 years, Egypt, 3 years, Chile, 8 years, Jordan, 9 years. So, once the EU signs the deal, you really have to, spend lots of time to, convince the trading partner to have a similar arrangement. So it's a bit, difficult. Therefore, yes, customs union is a good thing, but the arrangement on how to sign agreements with third countries and getting rid of this asymmetry is truly within the institutional framework that you have to create with the European Union. Otherwise, it's very helpful.
So to add on the replicated agreements, just for clarity, even if we enter into a customs union with the EU, we still have to replicate all of these agreements. There's no automaticity. They do not automatically apply to us. So that's still the case. And just to add one extra thing to what David has laid out, many countries, and this is why the Swiss and EEA, so Norway, replication is partial, is that it is conditional on the UK-EU's relationship as to how much further they are able to go. And one country in particular is incredibly dependent on the future UK-EU relationship, and that's Turkey. Unless the UK is in a customs union with the EU, it probably will not be able to replicate its customs union with Turkey, because we're talking about the EU-Turkey customs union. The UK is currently in a customs union with Turkey. If we want to replicate what exists now, we would also have to be in a customs union with the EU. And I think that's something that's underappreciated, because people don't necessarily realise, just on the scale of how important our trading partners are, just how high up Turkey is.
Just two or three very general points. For a start, most of the trade deals don't actually matter a great deal, because we don't trade very much. In Tunisia, we have very little trade.
But if you take an example,
but the important ones.
If I could just take an example, because I think I think if we can get beyond the don't matter very much to something that is actually specific, as an example, a business in my constituency uses about 10 of those and is a high-class manufacturing business. So I think we need to get to some more specific evidence, I think, beyond it doesn't matter very much.
David has just said that it's up to the DIT, isn't it? And my understanding is David's understanding, that already 9 of them have been essentially ready to roll out if we leave, including Switzerland, which is one of the most important of our trading partners that isn't in the EU. When it comes to actual trading, negotiating new trade agreements, well, I don't know how well those may be going, but obviously DIT is trying to work at them. But because there's so much ambiguity and uncertainty about our leaving, that I suspect they're not going as well as they might do. But I'm not privy to those discussions, so I can't really offer you any more.
Yeah, perhaps just pick up on what Sam said, and I think it's completely true. The last evidence that I have given, it was a month ago, on the continuity of the Turkey-UK trade relations, and because the DIT, declared that they will not be able to roll on the agreement with Turkey, and it's one of the major trading partners. So it's really bothersome, especially the British steel industry said it very clearly that already the UK steel tariffs are very low, so the Turkish steel exporters to the United Kingdom perhaps won't have much problem. But if the United Kingdom does not, leave the European Union with an agreement, and if they don't have an agreement with Turkey, then the tariffs that will be applicable will start from 16% or something around that number. So it's important as a country where you have to roll all of these agreements, and I think there's a major point in why you really have to follow those agreements once the EU does.
I'll just follow up, because I think there's one point that hasn't been answered, and it was this point about us being a country of 60 million and having multiple agreements where we can sustain the economic potential benefits from those, because currently you could have agreements whereby you could have exports to multiple EU countries, and we may be a part of an arrangement maybe with one exporter from another country. So I'm just asking a practical point from any analysis that you've seen about what we could sustain.
So I think I actually agree with David in that the UK is still a significant market, so countries will still want to discuss with us. Whether they make the same concessions they made to the EU is another question. And I would imagine part of the hold-up with, say, the discussions with Korea, for example, is because Korea does not want to make the same concessions it made to the EU. One other issue I would just add into this is that we should be aware that the replicated agreements might not be as beneficial to our exporters as they previously were because of the rules of origin issue. So to use Korea as an example, in order to qualify for the zero tariff preference afforded under the EU-Korea agreement, you have to be able to demonstrate, if you're exporting a car, that 55% of the value added was created in the EU. Once we've left, 55% of the value added will have to be being created in the UK. And that's a problem, because if you take the higher limits of value added when it comes to the automobile industry within the UK, it's about 40%, 41%. So we don't meet that threshold. Can we negotiate provisions that can help on this? Yes. DRT has actually successfully managed to do that when it comes to UK-Chile replication, in that we are going to continue to be allowed to account for EU content as being local for the purpose of meeting these thresholds. But not all countries will be as accommodating as Chile, and Korea being the specific example where the sort of word on the street is that they said, OK, we'll discuss that so long as you consider accounting for Chinese inputs as being local in Korea. And to be blunt, the purpose of rules of origin is to keep out Chinese inputs. So that caused some consternation.
Okay. All right. Howard Williams.
Thank you. Can I ask you about something which is really quite specific and which matters a lot to my constituents? And that's the Protected Geographical Indicator Scheme that the European Union has, along with a couple of other ones, the Protected Designation of Origin and the Traditional Specialities Scheme. Now, thinking sort of post-Brexit, these apply in Wales to such things as Welsh beef, Welsh lamb, and really specific things such as salmon caused by coracle on the rivers Teifi, Taf and Towy. And, you know, these are very important rather than being not very important for those particular producers. Now, the EU has bilateral agreements that they've come to with third countries. And I'd just like you to tell us, if you can, broadly, you know, how these were negotiated, how long they took, how do they operate, and has there been any attention to these particular aspects in the negotiations so far with the European Union? Is it anywhere on the agenda? And lastly, do you know of any proposals for a similar scheme within the UK post-Brexit so that we could have our own designated scheme?
Okay, I'll give this a go. I've done some work on it. I mean, geographical indications are one of the EU's absolute top priorities. Food and drink generally is at the core of a lot of free trade agreements because it's one of the most protected sectors in terms of goods trade, and so it's often at the core. And the EU's geographical indications scheme has really, it's done wonders for EU exports, frankly, that, basically you can get premium pricing, and if you have that recognised, then you're, for certain products you will find that then, nobody can pretend to be Scotch whisky or other products. Now, the geographical indications appears within the withdrawal agreement at the EU's request on intellectual property grounds, and they want us to, essentially that would mean that the UK would maintain protections on EU indicators and vice versa, so that Welsh lamb and the like would continue to be recognised. Now, there is an issue with that, which is that US trade agreement and indeed the Trans-Pacific Partnership both have language which is to try to sort of reduce the power of EU geographical indications, which means that you'd have to have a process by which they could be removed. Now, there is some protection in the US, and a product like Welsh lamb is actually probably okay because where it's very specific, it's unlikely that anybody in the US is going to try and pass off another product as Welsh lamb under their trademark rules. But that is, if one looks at some of the politics around the people who would like to rewrite the withdrawal agreement, you will find that they take out geographical indications because they're aware that it's an internationally controversial issue between the US and the EU. Now, in our replicated agreements, I think I'm right in saying that we continue to recognise the geographical indications in the few that have been done. It is also worth saying that we have more geographical indications than are actually recognised in a trade agreement. So, for example, within the Canada trade agreement, I think it's only around 150 EU-wide indications are recognised, even though there are several hundred more. But it's generally thought that those are the most important ones, and I'd have to check which exactly have been included. But these geographical indications in the UK, they include the Welsh produce you mentioned, they include in Scotland, they also include, I think, Melton Mowbray pork pies. These are not always reflected in the trade agreements because it's often the case that these are just not issues in other countries, that nobody is trying to pretend that they're creating Melton Mowbray pork pies. I think I'm right in saying that's not within the Canada agreement, but I would have to check. But yeah, it's very definitely there, and it certainly should continue. In terms of economic grounds, what can you gain from a trade agreement? Yes, you can gain quite a lot in these areas, and maybe we should consider having more geographical indications.
One thing I would add is that even in the event of no deal, and I think I'm right in saying that most people who advocate for no deal argue that we should still at some point in the future have a free trade agreement with the EU. It's just seen as a route towards a rupture followed by a later negotiation. Any free trade agreement with the EU includes geographical indicators, and we can see this in recent history. So the upgrade of the EU-Mexico agreement included GIs. EU-Japan managed to get over the line, partially because of the US absconding from the TPP, but also because Japan took on board GIs. And there are lots of arguments against GIs, but one thing is certainly true is that the EU is winning this battle globally. It's managed to get GIs into both the country north of the US and the country south of the US. It's got them surrounded. So they're not going to agree an agreement with the UK that doesn't include them, although David's point is pertinent in that within the FTAs, the number of GIs might be less than you would find within the EU, just because of for many different reasons.
I mean, I agree with exactly. There's no river Towie in the United States, for example.
Yes.
And just the points I raised about how how long it takes to negotiate these sorts of things. It is part of seats, and that did take, was it 7 years or more? So it's not going to happen tomorrow morning, is it?
Well, yeah, the EU is generally a little slower to negotiate trade agreements than than other countries, but only a little. So I was talking to a friend from Australia, and he was saying that Australian trade agreements, that some have been very quick, but others have taken 5 to 10 years as well. So trade agreements, just because, I mean, what you want to make sure is you want to make sure that all the companies within your constituencies all have their opportunity to benefit from trade agreements, and to get that information and then to go around the process numerous times of to how to remove whatever barriers they happen to have just takes a lot of time. So, you know, the length of time it takes is to enable you to get the greatest benefit. It's not because bureaucrats, as I used to be, like to take a long time.
And often you're just waiting for the right political conditions, in that you can negotiate pretty much 95% of a trade agreement by boilerplate. So just it's the same, and it's the final 5%, and that's the controversial bits, because this needs to be understood, I think, in the EU debate, Brexit debate as well. In every decision comes with trade-offs. There are going to be people who benefit and there are going to be people who lose. And that's true of any trade agreement. So actually waiting for the right political moment in which you can actually get something over the line is important. There's a reason the EU-Japan agreement happened after Trump and after the US removed itself from TPP, because all of a sudden it created a moment whereby there was actually public buy-in to the idea that we're not Trump. We actually want to look outwards. And it managed to get over the line. So often it's not necessarily the technical details that hold up a trade agreement, or is it, or
our best.
You know, but it's often just when can we actually get the public on board with this, and you have to wait for the right moment, and it's not always in your control.
Okay.
Perhaps I would just add to that. I mean, it is also to a certain extent difficult because we don't have classical trade agreements anymore. We have really comprehensive and deep trade agreements where you have all sorts of subjects which are going into it, including the GIs. Therefore, yes, there's a political willingness, but at the same time, because the issues are so technical, sometimes it may take time. And again, on your question, within the World Trade Organization as well, within the TRIPS, the Trade-Related Intellectual Property Rights Agreement, there is the protection for GIs. And so even if you don't have an agreement with the European Union, you know that under the World Trade Organization, you will have some, protections for the geographical indications.
Okay, Chair Amelia Fry.
Thank you very much. Can I just ask, particularly Mr. Lowe, you referred earlier to the advantages in the customs union in respect of rules of origin. How would you quantify that compared with, say, advantages in lack of tariffs? Is it equal in benefit or twice the benefit? Or
Just to be precise on the question, lack of tariffs between who?
Within the customs union.
So what's more important, the tariffs?
We are, yes, exactly. What's more important, rules of origin or lack of tariffs within the customs union?
So it's difficult to exactly trade off, because the lower tariffs outside of a customs union only exist if you can qualify for them. So if you actually meet the rules of origin requirements. But in terms of when people try to quantify the cost of rules of origin, it's usually put at between 2 to 6% of the value of the product you're exporting in terms of the compliance cost. So if you think of that as a tariff equivalent, it does really vary insofar as it might be really easy. So for whiskey, it's not that difficult to prove that the barley and water became whiskey. So there's really hardly any compliance cost there. But say a complex piece of machinery, it might be a bit more difficult. So the cost is around 2 to 6%. But then the additional cost is, so that's the cost if you can qualify. So if you can qualify because you meet the criteria, that's the additional cost and you have to trade that off against what the tariff would be. So is it worth just essentially absorbing the cost of the tariff for your seller and just doing it under WTO because the rules of origin cost is too great? But the second order issue, or actually probably the first order issue, is do you qualify? Because if your product doesn't qualify, then you're going to get hit by the tariff, the MFN tariff, regardless, even if there's a free trade agreement in place. I hope that answers your question.
Yeah.
Could I just
By
say,
much, yes.
I mean, always with these things, the figures are always contentious. And I read something in briefings for Brexit recently, and they were quoting a WTO study, recent WTO study, which suggests perhaps rules of origin costs, abiding by rules of origin costs were perhaps 1% of trade, just 1%, whereas when you're talking about an average tariff cost, you're talking about 4.5%. But then you get switches in currencies, and they just drown them out. You get a 10% movement in your currency, it just drowns it out. So, the problem is the figures are always contentious. But I get the impression that the rules of origin compliance costs are not formidable, let's put it that way, or not forbidding. So, I mean, if you're discussing the option between a free trade agreement where you have to abide by rules of origin agreement and customs union, it doesn't make, apparently, a great deal of difference.
Well, we know it does because of the preferential utilisation rates of free trade agreements, which aren't what they should be. You'd hope for something near 100%. In recent EU study, it varies by country. Some countries are better at it than others, but you're talking around 60-70%. So some products aren't taking advantage of these free trade agreements. And also, when we talk about costs, we have to differentiate between two things. The paperwork itself is not very expensive. It's sort of £30 to £50 at a Chambers of Commerce. You get it stamped per shipment. So in the scheme of things, you can live with it. The actual cost is the audit cost of actually making sure you're compliant with the criteria that is set out in the trade agreement. Because if you are not, it won't get found out immediately, but at some point you might have an HMRC audit that comes through and says, actually, your product does not qualify for this. And then the person or peoples that get hit with the cost of you not complying isn't necessarily you, it's the person you're selling to, because it's importers who pay tariffs. So all of a sudden, in their other jurisdiction, they're going to get hit with this tariff bill, and that does not do great things for your reputation as an exporter, as a trusted seller. So you really want to be on top of it. So there's paperwork costs, and then there's internal business costs, and the cost of just employing someone or people to keep on top of it, which is why, as I would acknowledge, there is a range of estimates insofar as to how much it costs, and it does vary product by product.
Thank you very much. Could I move on to services, which obviously is extremely important for the UK, and which we have a trade surplus with the EU of £28 billion. I wanted to ask generally whether there's been too much focus on goods trade in this debate, but more specifically, how far the EU has been willing to liberalise trade in services with third countries. This has come up quite a lot in the House over the last few years, and is there any reason to expect that the EU, based on the indications in the political declaration and other statements, would be willing to treat the UK more favourably than other third countries as far as services were concerned?
So I've written a paper. I wrote a paper on this in December. I think I spoke to this committee about it. Maybe not. Just trying to answer this question: is the EU willing to go further than it has before when it comes to free trade agreements? And I think the starting point should be: if we're not prepared to accept freedom of movement of people, if we're not prepared to remain within the regulatory architecture of the EU, there are limits to how far the EU will go. So for the most part, in terms of its future relationship with the UK, services will be dealt with on the same basis as they treat most third countries. In the context of free trade agreements, they might make additional commitments on procurement, intellectual property. In terms of services and market access, the EU largely just reaffirms its GATS commitments, so it doesn't go much further than its WTO obligations. Areas where it could potentially go further, even if we're in a free trade agreement type scenario or a customs union with a services annex on it, but we're not in the single market, is potentially on mutual recognition of qualifications, although it is difficult because it's a shared competence with member states. So actually, when you look at what the EU has done on mutual recognition of qualifications in the past, say with Japan, it has created a dialogue whereby it encourages the bodies within each member state, some of which aren't even part of government, if you think, or they might be at arm's reach, to enter into dialogue, say, with the same bodies in Japan to come to a conclusion. The other area where the EU will probably go, it's not necessarily going to go further, so it's the same provisions as allowed for all third countries, but the UK might be able to take advantage of them where it has not before is when it comes to equivalence and financial services. So equivalence, as the EU sees it, will not be part of the negotiation because it's a unilateral decision, but there are many areas where equivalence can be offered where it hasn't been in the past, where the UK could potentially qualify. In terms of impact on the services industry, I think when you sort of look at it and compartmentalise by sector, in terms of direct exports, you see the biggest impact being in financial services, which can be offset somewhat by the equivalence regime, but not entirely, and those services will be continue to be provided but via an establishment, a subsidiary within the EU, because the EU is very open to establishment and will be to the UK. When it comes to, say, business services, you'll still see an impact, but because of how business services already structure themselves, as in most of them, the big consultancies already have offices in the countries in the EU countries they want to serve, it won't be as direct, although you will have issues along with movement of people. The big question is if the UK is willing to be very open on movement of people, is there a possibility to go a bit further in some of these areas? And I think perhaps, but we shouldn't kid ourselves. And actually this is one of the few areas where the government has been very consistent when it talks to the trade-offs. In terms of the Chequers proposals, the bits on services, it was ambitious, but it was in the realms of reality in that it acknowledges that not wanting freedom of movement means that there will be quantitative restrictions on our ability to provide services from the UK in future to the EU.
Okay. Sorry, Ruth, yeah.
I was going to say, I was going to keep the single market in services in proportion, because I remember there was a whole series of competencies, the balance of competencies surveys that were done by government. 2013 was around then, and they did a big report on the progress of the single market in services, and they concluded actually that it was a long way to go, and that the Services Directive of 2008 really hadn't made a great deal of progress. So the services weren't terribly well integrated within the single market. One of the exceptions was the financial services, where the passport, I think, it's perhaps a bit of a mixed blessing, but some of the financial organisations do actually quite appreciate the idea of the passport, where you just register with one regulatory authority in an EU or an EEA member, actually, and then you can have your services throughout the EEA, and the passport would go. But as Sam has just said, within the talking about equivalence, there is a mention of equivalence within the political declaration, but how far that will be negotiated, it's not quite the same as the passport, but at least you're talking about equivalence of regulations that may actually do something to ameliorate the loss of the passport. But I think we need to keep it in perspective. The single market in services is actually not that well developed.
Although I would just come back on that and say that the single market in services is the only example of comprehensive services liberalisation between multiple countries globally since GATS. It's the furthest anyone has gone. And it does suggest that there are inherent difficulties to liberalising services, where even if you create the institutional architecture that sits above it, it's still difficult. And to give a specific example, it's easier to get your qualifications recognised across the EU than it is within the US. So the EU has in some way, some areas, specific areas, liberalised its services markets more than a single country.
Like I say, we just keep it in perspective. That was what the balance of competencies were saying.
Well, I've been trying to come in, I'm afraid, because I wanted to give some specific examples. It's all very nice and very general. Let's just give some specific industries. Road haulage, we will have restrictions as a non-EU member in terms of providing cabotage between EU countries. Travel services, where you have currently travel reps perhaps working out in the EU who wouldn't have that right to work there in the future. I hear quite a lot from individual IT suppliers or whatever. They require various people to work around the EU. In the future, they may not have that access to be with the working visas. Areas like quarrying, where you have specific requirements in a lot of countries, where you have restrictions on non-EU countries providing those services. Provision of public services, which is by and large outside of any trade agreement, and that is a big area for UK companies. And finally, audio-visual, where at the moment the UK is quite a hub for provision of television services across the EU, and already a number of companies have moved. So there's just a bunch of examples of where you're affected in terms of services.
Thank you. I've got some others, but I realise you want to bring others. If I could come back at the end. Yes.
Thank you very much, Stephen Kinnock.
Thank you very much. I just had a question to follow up really on what Pat McFadden was asking earlier about the free movement of lorries. So this issue around trucks, and particularly at the Turkey-Bulgaria
border. I mean, it seems that the case is that, you know, a customs union or a form of customs union delivers free movement of goods to a large extent, but it doesn't deliver the free movement of trucks. It seems that the main issue there is around free movement of people and free movement of labour. So you can't have the free movement of trucks if you don't have the free movement of people. By definition, they're driven by people. My understanding is that you have a certain number of transport permits there, and that the only countries that the EU has open access road transport deals with are the European Economic Area countries. So can you say a bit more about how this issue of road transport would work if the UK were to leave the European Economic Area?
Turkey, you need to negotiate with, independently with the members of the European Union. For instance, in the case of Bulgaria or Romania, because Turkish trucks also had problems with Romania. So these quotas or permits that you mentioned are the living examples of the problem. So basically, a Turkish lorry which starts from Istanbul to its trip, which goes through Bulgaria, Austria, because Austria had the same issue. So basically, you need to negotiate with the country how much quota or how much, licenses or permits a day they will provide to you. For the other countries, for the EA, yes, there's another, potential, but you're not going directly to the EA countries. You have to pass through the border. Therefore, as it stands, that's a bleeding problem. And after the decision of the European Court of Justice, we're hoping that things may improve, because this way you can have some saying with the independent individual member states, that there's a court judgment. But, as it stands, I cannot offer you a perfect solution, to the extent this policy will be within the hands of the independent member states.
So if the UK were to leave the European Union and just have a standalone customs union, and not an EEA-style relationship, we would then have to negotiate quotas with each one of the member states for whether or not our trucks can go through those countries?
Well, perhaps we shouldn't generalize that much, because after all, you're dealing with 27 countries, and in Turkey's experience, we have problems only with 2 or 3 countries. So it doesn't say every country will create the same problem. So depending on with whom you're shipping your products much, it will depend on what kind of arrangement you have. So I cannot say for France, I cannot say for Belgium. It truly depends on their policy regarding the road transportation.
Thank you very much. And just one final question on this issue of the difference between goods and services eliding. Back in September, Michel Barnier described the single market for goods and services as an ecosystem that has grown over decades. You cannot play with it by picking pieces. This is another reason why I strongly oppose the Chequers proposal. There are services in every product. In your mobile phone, for example, it is 20 to 40% services. So a question to anyone on the panel that would like to address that. Would you agree with Monsieur Barnier's comments there that customs union without single market is not really worth the paper it's written on?
No, I don't entirely agree, because it still obviously has benefits, and all free trade agreements in essence split services and goods, insofar as they don't do very much on services and they do quite a lot on goods. Switzerland is in the single market for goods, effectively, not single market for services. Is the general point about our services and goods intertwining is absolutely right. If you think about UK exports, goods exports, it's been estimated about 50 billion of the value of our goods exports is actually made up of services inputs around them, and that's quite significant. It's around the same as financial services exports. So it matters. But in terms of the consequences for the EU of, say, a customs union when it comes to the services value added in goods, so say, for example, a Rolls-Royce contract whereby they lease the engine, but and it comes with a contract to maintain it, to monitor it and maintain it. On the services issue, we could still provide the engine from the UK, but the legal contract would probably have to be signed in the EU, and the person who actually maintains it and monitors it established in the EU. So in a sense, it would actually, on the services side at least, benefit the EU insofar as that economic activity would have to be located there. Does it make it less beneficial for the UK to have a customs union without everything else? Of course, we're talking about degrees of disalignment in terms of how do you ensure that there's no or very little negative economic impact. You stay as close to what we have now as possible. The further you go away from that, and customs union is on the FTA end of the spectrum, it's not on the single market end of the spectrum, the more damage you have.
But, I mean, there's a general problem with trade agreements at the moment anyway, is that they are falling a little bit behind the nature of the modern economy, the intertwining of services and goods. What do you do with data? And if you talk to, for example, the car industry at the moment, trade, yes, they're worried about trade, but they're also worried about who owns all the data in the car. And there are so many questions that really we're all still trying to get to grips with. So it's not just... there are other conversations other than Brexit going on in some industries. They're just about managing.
Okay,
thank you.
Stuff full of services, it will be defined as a good, and if you look in the standard industrial trade classification, it will be defined as a good.
I just had a follow-up to Stephen Crabb's questions around the political declaration, and clearly the European Union has said that if there's going to be a change to the deal, it has to be done through the political declaration. But I was just wondering that, from the point of view of the EU, have they set any limitations in terms of what they're prepared to discuss on the political declaration? Have they put in their own red lines, and have they delineated between what they want to discuss now as part of the political declaration and what they might agree with, but they say, well, that's not for now, that's for later? Perhaps David Hennig.
There's an element to which the EU has steered the political declaration in certain ways, and people have put up parts, for example, about the language around the customs, building on the customs arrangements. But actually, I think the EU has been pretty open to the political declaration. It's a starting point. They're trying to steer us into one of their existing, roughly, models for the future, including the customs union. And that will help steer the conversation, was what I was going to say earlier to the earlier question. If we say it's a customs union we want, then we'll be having the kind of conversation we've had really today in negotiations. You'll be talking about the details of customs union, whereby if the political declaration stays very vague and open to many different arrangements, you're going to start a much further back point in discussions of, what is this future relationship? You're going to have a lot more scope. So the EU has not been, I don't think it's specifically put in the political declaration their red lines that must exist.
You think they would want it to be vague?
No, I think they would prefer. It will be quicker to negotiate if both sides have a sort of shared understanding of where they're going. Without that shared understanding, the first thing you're going to have to do is to try and build that shared understanding. How long is that going to take? We don't know. Are there EU red lines? There are many EU red lines that are not in the political declaration. As I say, many of them are to do with precedent. If we look at if the EU is going to move beyond the Turkey model in terms of the customs union, or if we're going to make changes want to be on the EEA track, or if we want a free trade agreement, they will all start with where we are at the moment. And there's some red lines in there that we can identify.
Okay. Craig, you had a very quick follow-up.
For you, David, actually, I understand you were involved with the TTIP type of negotiations, so a specialist. Now, this actually mixed up with Dr. Artıran. I understand that there were demonstrations in Turkey when TTIP was being negotiated, because I assume Turkey had no part in any of those negotiations. They're going to be done for you by the EU. Now, we had quite a vocal discussion in the UK, at the 8 Degrees and all those great people, sending us streams of emails saying the NHS is under threat from TTIP. We all probably had those. Would it be true to say that a TTIP of the future, an EU-US negotiated FTA that we're not part of, could include procurement into all aspects of public life that the EU might be comfortable with, but wouldn't suit the UK domestically, but we'd have no say in it at all, and we'd have the demonstrations on the streets in London, as we had in Ankara and Istanbul, but they'd be largely irrelevant because they'd mean absolutely nothing, because we'd have nothing to do with it whatsoever.
So this is on the assumption that we're in a customs union with the EU, and the EU is negotiating with the US on our behalf. But first, I think this comes back to the design point of the customs union. First and foremost, is you're going to have to make sure if we're in a customs union, we've designed out that possibility, so that that cannot happen, so that the EU cannot negotiate that on our behalf. I mean, I think a second point on TTIP, and yeah, I'm sorry you had all those mails, all my fault, would be that, you know, if you were having an EU-US negotiation as ambitious as TTIP again, I would strongly recommend that the UK try to barge our way in and make it a three-way negotiation, because we were going to be one of the main beneficiaries of it. But you may, having received all those mails, not be in favour of it, of that. But essentially, this is the kind of point where it comes on the follow-up to the previous question. Essentially, if we know it's going to be a customs union, we need to be thinking about all these possible issues and putting them up front, so that we have ways to avoid being in a situation where the EU is negotiating something on our behalf that we don't like.
If we set up a customs union with the same apologies to Turkey, impotence as Turkey, my scenario that I outlined could happen.
Not in terms of procurement, as it happens. It would only be in terms of goods tariffs. That's the only. So at the moment, they couldn't negotiate access to our procurement, access to Turkey's procurement market. In fact, the EU and Turkey are still negotiating on EU's access to Turkey's procurement market, just bilaterally. Okay. So not as it happens, that specific example.
Jeremy, did you have one final?
Yes, I just wanted to ask about the balance between free trade agreements and access to markets. In talking with the Secretary of State for International Trade last week, I was quite struck by the fact that he was using the expression access to markets much more than free trade agreements, and giving examples of where actually the future may well be limited specific agreements in certain areas, whether it's data, whether it's certain aspects of financial services, rather than broad-ranging FTAs which become highly political and involve an awful lot of offsets. Are we seeing generally in world trade discussions a move towards those more specific targeted areas which can be a benefit to both countries or both groups of countries, rather than an omnibus FTA which becomes almost impossible because of so many differing political and other interests?
So I think we are moving away from the era of FTAs. I'm not sure we've quite hit the era of specific agreements, but I'm glad to hear that that's what the Secretary of State said, because I think that is a way forward. Sorry, that's on.
Well, I just wanted to say, I mean, in FTA, according to Article 24, similar to customs union, you have to liberalize substantially all the trade. Now, if the data flows or if the financial services cover 90% of your trade with the other country, with the EU, then you may do so. But if you're not covering substantially all the trade, the same rules apply. So I don't see how you're going to just sign an agreement which is going to be based on the, on the purposes, on the lines of data flows or financial services.
I think going beyond actual agreements, I think perhaps there will be more of this in the future. I think the UK, I think people get a bit miserable about things. We were saying, well, if we're in a customs union, we won't be able to have a trade policy. We still absolutely have to have a trade policy. We just have to work out how to make it work. So if we were in a customs union, would this be something that we were pursuing to try and do more narrow discussions, arrangements out within the competence that we have that's exclusive? Then yes. And to give the sort of example of the things the Secretary of State might have been referring to, Vietnam has got pretty close to agreeing a trade agreement with the EU. It's not over the line, which involves some tariff reductions. But for a certain company, Vietnam agreed these tariff reductions and then instantly, despite the fact it's not enforced yet, put in domestic taxes that had the equivalent effect. So WTO compliant, actually, so there's no WTO issue even, but it is a problem for that industry, and it means that as the trade agreement hasn't actually come into force yet, they're already having the dual whammy of the tariffs plus the additional taxes. Now, is that something that the UK could be prioritising as a bilateral discussion with that country?